Good evening. Welcome to our HOA workshop. It's great to see you all. Thank you all so much for coming, especially on this beautiful late summer, early fall day. I really appreciate your being here. I am about to introduce our speaker, Jeff Smith, but before I do, I just wanted to let you know on Thursday, October 10th, here in this room at the Funplex, we're going to do a City of Greeley focused HOA workshop. So it will be focusing on codes and just anything related to the City of Greeley that's specific to the City of Greeley that are things that might be of interest to HOAs and residents of Greeley. So we will be sending out a news release for that and taking RSVPs. But that again will be Thursday, October 10th, and it will be at 5:30 here at the Funplex. Now I'd like to just real quick also mention the city is restarting our Neighbor Labor Program, which is a volunteer opportunity for when somebody has a need. For example, they broke their leg and can't shovel their sidewalk. Then we'll have a volunteer opportunity for people to sign up and go volunteer to help that person. We're restarting that program, so stay tuned for that. If you have questions about it, shoot me an email. And then also we are, the city has hired a consultant to do on-call mediation services. So that will mainly be for code compliance issues that will be between the city and the offending property owner. But I just wanted to let you know about that program as well. So now I'd like to introduce our speaker for tonight, Jeffrey Smith. He is with Altitude Community Law. He is a shareholder with Altitude Community Law and has been with the firm since January 2012. He is head of and oversees the litigation department. And during his time with the firm, he has handled foreclosure matters, covenant enforcement matters, general litigation matters, collection matters, and transactional issues. He graduated from the University of Denver's Sturm College of Law, and prior to law school, he graduated from the Providence College in Rhode Island, where he competed in the Big East as a 4-year scholarship athlete on the men's soccer team. When he is not at work, he is likely spending time with his wife and 4 children, or he is enjoying the outdoors by golfing, skiing, or playing soccer. Please join me in welcoming Jeff Smith.
All right, good evening, everybody. Hopefully you guys can hear me. As said, I'm Jeff Smith, and I'm one of the owners of Altitude Community Law. We are the largest HOA firm in Colorado. We have offices in Loveland, we have an office in Frisco, an office in Durango, an office in Colorado Springs, and our main office is out of Lakewood. We do almost exclusive HOA work. We do a little bit of Metro District work, but the vast majority of what we do is HOAs. This is why we're here to talk. We're going to be going over some fair housing laws, as well as 8 meeting mistakes. I said I'm the head of our litigation department, so the fair housing laws area is my specialty, but I can also get us through the 8 meeting mistakes as well. Just in case you guys don't know, if you go to our website, we have a ton of additional resources there. There are lots of articles that have been written by the attorneys. We have a Facebook page, a Twitter. I don't really do anything with those things, but there'll be little blasts when there's new laws that have come out. There were a bunch of new laws that were passed in this last session. I would anticipate a bunch of new HOA laws that will come out in the next session as well. There's already rumblings about different things. But it is a great resource, a great spot for you guys to start. It's probably better than starting off with Google. It can at least get you a general background of what the information is, and general understanding of the HOA law. I apologize, I've not done an in-person class in years, so I'm so used to doing Zoom. This is a little strange having like actual people looking back, and it's kind of fun. All right, so let's start off. All right, federal statutes relating to discrimination. You have the Civil Rights Act. You have Title VII of the Civil Rights Act, which was amended in 1988. You have the Rehabilitation Act, the Fair Housing Amendment Act, which is the one that's going to be most prevalent for associations. American with Disabilities Act, which most owners will believe apply to HOAs, but typically it's going to be the FHA, not the ADA. And then the Air Carrier Access Act, which doesn't seem like it would apply to us, but it comes in generally with animals and what's been going on in the airline industry with emotional support animals. So this is one case talking about the Aviation Act. Emotional support animals, as we'll get into a little bit more as we go on, can be any type of animal. In this case, it was a big pot-bellied pig. People have been, so let's start off first. Emotional support animals serve a great purpose. They do lots of wonderful things for those people who need it. Unfortunately, because of how broadly the law has been written, people have been taking advantage. And one of the ways that they do that is to fly their animals for free on planes. Because of that, you started to see a bit of a crackdown as to what is an ESA. And so that's really what this picture, this is a real picture. This pot-bellied pig was apparently pooping on the plane, howling on the plane, causing all sorts of issues. But that's just an example of people stretching the rules, where once you start stretching the rules, you start getting repercussions in terms of the government starts trying to change things. So we'll start off first with the ADA, the Americans with Disabilities Act. This prohibits discrimination and ensures equal opportunity for persons with disabilities in employment, state and local government services, public accommodations, which is where it will sometimes come into effect for an HOA, commercial facilities, and transportation. If you want to look up the ADA, it's codified at 42 USC 12101. All right, so most of the time, as we briefly talked about, ADA is not going to apply. ADA applies to places open to the public. Most HOAs are going to be only open to members and its guests. However, sometimes that you will see a couple situations. One, a pool sometimes will be under the ADA if you opened it up to people outside of the membership. So if you are having a swim meet, if you are allowing individuals that are outside of the membership to buy a guest pass for the season, something along those lines, ADA may become applicable at that point in time. So that's one thing to think of. Also, if you have a building, you see it more in Denver, downtown Denver, where maybe the first floor is going to be a restaurant, and then above that will be the actual residential area. On that first floor that's open to the public, that restaurant, that would be subject to the ADA. But the residential area above would not be. Those are kind of the two main things where you're going to see ADA come into effect for an HOA. All right, we also have Colorado statutes that deal with discrimination. You have the Colorado Civil Rights Act, which is codified at CRS 2434501, which is going to relate to housing practices. It does allow for actual damages. It'll allow for civil penalties if your association is found guilty of violating the statute. Insurance is not going to cover something like that. In almost every insurance policy, there's going to be a provision that says it does not apply to a discrimination claim. So when we're talking more about the CCRD, which is the Colorado Civil Rights Division, you'll hear a little bit more about that. It also allows for attorney's fees. So if an owner brings a claim under the Colorado Civil Rights Act and wins, they're likely going to be entitled to their attorney's fees as well. All right, so the FHA, it's going to prohibit discrimination against certain protected classes. Those protected classes are broken down into different areas by race, creed, which is going to be Colorado specific only, color, religion, sex, handicap, disability, familial status, marital status, which is again a Colorado only, national origin, ancestry, sexual orientation. Those last two are also state only. The highlighted provisions are the ones that are most likely to come up in an HOA. Religion, not that often, but it does come up from time to time. Handicap disability is a huge one. That's what most people will latch onto. And then familial status comes up a fair amount when we're talking about rules, especially pool rules, something like adult-only swim, things along those lines. Those are going to fall under the familial status discrimination. So different types of discrimination. There's refusal to accommodate a protected person. There's discriminatory treatment, which would be provisions that discriminate on their face. There's disparate impact. Those are facially neutral rules, but the discrimination is based on the impact of it. And then you have refusal to allow modification to property for a protected person. So an example of discriminatory treatment would be, just like we just kind of talked about, but a rule for adult only or children only, like pool rules or playground rules. This has been considered to discriminate against families. You have a disparate impact. That would be, an example of that would be, say, a noise rule that only applies to children screaming and playing outside. So if you have a common area and you say you're not allowed to have any loud noises or balls being thrown, things along those lines, those are really only going to be focused on children and not focused on everyone in the community. And so that's why that's a disparate impact. So it's something that looks facially neutral when you look at it, but it's only being applied against a certain subset. And then you have refusal to accommodate or modify a disability. We're going to be diving deeper into that here shortly. How does this apply to homeowner associations? So when an HOA has a covenant or rule which prevents a homeowner from using and enjoying their home because of one of the listed protected areas, and the HOA refuses to make a reasonable accommodation or modification, when the association fails to fairly and consistently apply its governing documents to all. So ultimately, anytime we have one of those protected classes that we were just talking about, anytime the association treats a member of that class differently, that's going to be discrimination. It's not what we often think of as discrimination in terms of this person's a bigot or this person's making racial remarks, things along those lines. It's much broader than that. All right, discriminatory-based harassment, quid pro quo. So the Fair Housing Act prohibits discrimination. Most of the time, the issue to the HOA is don't discriminate. Treat everyone the same, whether it's a woman, whether it's a man, whether it's a same-sex couple, a married couple, any of those things. We want to treat everyone in the same manner. In October of 2016, the U.S. Department of Housing and Urban Development, HUD, adopted a final rule to amend the Fair Housing Regulations contained in 24 CFR Part 100. This helped to formalize the standards for the investigation and adjudication of claims of violation for harassment based on race, color, religion, national origin, sex, familial status, or disability. So ultimately, in 2016 and before that, we gave an enforcer. So in Colorado, the enforcer of these discrimination claims is typically going to be the Colorado Civil Rights Division. Above that is the Colorado Civil Rights Commission. And so if you have a claim filed against you with the CCRD and you go and you have your mediation and then there's a final ruling, you can then appeal it to the CCRC. So think of the Colorado Civil Rights Commission as kind of being like the Supreme Court in your Colorado, and the CCRD being more like a district court. So you would appeal to the CCRC. So specifically, these rules are meant to address quid pro quo, kind of a tit for tat harassment, hostile environment harassment. While these types of discrimination are already recognized as violations under the FHA, they're not specifically addressed or defined therein. Instead, these violations were investigated and examined according to the standards established by the Employment Discrimination pursuant to Title VII. So with this new change, because we have so many people believing that HOAs, and sometimes true, that HOAs are cracking down on a specific individual, this 2016 clarification helped to show associations how they should be treating owners. Whether that's an owner-to-owner dispute, whether that's an owner-to-association dispute, ultimately it just gave us better guidelines as to how we should be dealing with these things instead of before we were kind of going under the employment side of it, which is where most of the discrimination claims began with. But because there was such a rise in complaints in a residential setting, we had to come up with new standards. So additionally, and perhaps most importantly for community associations, the new rules describe how the principles of directed vicarious liability shall be applied in the context of a fair housing violation to provide that a community association, its board members, managing agent can be held liable for the discrimination of others under the FHA, even if they weren't directly involved in the discriminatory conduct. So the FHA requires associations to take all steps that they can to stop discrimination. So if you have a owner who is making racially insensitive comments to another owner, these rules want the association to step into whatever they can. Now, the association is limited into what it can do. We don't have police powers. We aren't a court. But we do have typically covenants and rules that are going to talk about how you should treat other individuals in the community. Ultimately, what we're mostly going to do is send a letter to them saying, look, a complaint's been filed. Here is what they've alleged that you've done. we're all neighbors, we need to treat each other respectfully, something along those lines. There's not a whole lot more that the association can do besides that, but we need to take that step in order to help protect associations from liability, from an owner saying you didn't do anything about this. So that's one thing where it comes in, and that's kind of new. There was a case out of California in the last 5 years that really kind of drove down into this, and the association did not send any type of letter, didn't do anything, basically said, look, we don't have the ability to control another person, so they didn't do anything. And although we don't have the ability to control any individuals, we at least have the ability to remind them of kind of normal decorum and how to be a reasonable neighbor. All right, so familial discrimination. This is going to be based on family status. It's going to be dealing with, for kids, unequal treatment of children under the age of 18, unequal treatment of pregnant women, unequal treatment of families based on size or content. So again, when we're thinking about this, think about pool rules. So you don't want to have an adult-only swim time. What would be a better option, or an option that isn't going to discriminate people, is to have a lap time. So let's say whether you do 10 minutes at the end of each hour, or you separate out an hour during the day, and that's lap swimming. Anyone that, whether they're 8 years old, or 80 years old, excuse me, as long as they are there to swim laps and are just swimming laps, they have the ability to do that. That way you're not discriminating that this is only adult time, this is only children time. And that way everyone gets equal use of pools. Also think about rules where kids can and cannot play, no skateboarding. So oftentimes we'll see something that says no riding bikes on the sidewalks, on common area sidewalk. Oftentimes a court or the CCRD might view that as only applying to kids, because kids are mostly the ones that are going to be riding their bikes on it. Now in Colorado it's a little different because we have a much broader population of people that do ride bikes. So we've been able to successfully argue in some cases, depending on how the rules are written, that that is not discriminatory. But it's something that you need to think about. Often you'll also find in terms of number of people. A lot of your governing documents might say that only one family can live in a house. And it might say something along the lines of they have to be blood relatives, something along those lines. That is typically going to be seen as discrimination. Trying to limit whether it's a mother and father and 4 adult kids, or a mother and father and 2 random people that are staying there, the effect on the association doesn't change. So when you're discriminating based on just a familial unit, that can be problematic for an association. Of course.
Can we have a stipulation for no more than X number of people in the unit? Is that also discriminating? We don't talk about relationships. I forget if it's 2 per bedroom or something like that.
So typically that would be fine, because you're not carving out a subset, it's just saying X amount of people. Where you're going to run into possibly an issue with that is, I don't know how big the units are or anything along those lines, but if you have, like, I have a family of 6, and I have 4 relatively small children, you might have a hard time trying to enforce that against me if I have 3 little kids staying in one room versus 2. I mean, ultimately, it's probably not discriminatory, but whether or not you could enforce it would be a different question. Yeah?
So hypothetically, if it's in the documents that you're not enforcing, do the documents need to be amended, rewritten, etc., or is it an issue more of enforcement of the existing rules?
Yeah, so ultimately, if you have a rule in your governing documents, whether it's your covenants or your rules and regulations, you should be enforcing it. If you're not enforcing it, then the best case scenario is to amend it. However, if there is a state or federal law that trumps it, that would make it. So if you had a provision, there's only one association that I can think of in Colorado that still has a provision in that talks about you cannot, you have to be white to live in the community. That obviously violates rules, violates the federal law and state law, and so you can't enforce that. So you don't have to amend something like that out, but you would not be able to enforce it.
What about 55 plus communities? Is that considered age discrimination?
Nope. So HOPA, which is what you're talking about, is the only community that has the ability to carve out younger individuals. So that is HOPA is the federal law that allows for those. And so that is something that would allow Some of them are set up as no one under the age of here can be there. Some are set up that a spouse can be there, but you can only have a certain percentage, depends on what it is, but they are exempt from the age discrimination laws.
Thank you.
Another thing that you see come up a fair amount is, and it's been popping up over the last 10 years here in Colorado, is a company will come in, they'll purchase a house, they will convert the garage into 2 more bedrooms, and they will run either a drug rehab facility or a group home of some kind. That is obviously concerning to members of the association. However, we don't have the ability, and the association does not have the ability to prohibit that. They are a protected class, and there's nothing that the association could do to prohibit one of those coming in. Now, if an individual is still using, that is not a disability. But if they are not using and they're there for treatment, we don't have the ability to stop that. So that's another thing that has come up. We've talked about occupancy standards. All right, religious discrimination. So there's no duty to accommodate religions. There is a duty to treat all religions the same and remain neutral with all rules so they don't discriminate against religions. So where we see this the most is rules that talk about Christmas lights or something along those lines. Typically, you're going to want to refer to whatever it is as holiday lights. The best way to kind of set these up is because there's a random holiday every day of the year now. The best way is to do it by date. So something along the lines, I mean, most of the major holidays for a lot of the religions happen somewhere between the middle of December to the end of the middle of January. So oftentimes we will create rules that say you can have lights from December 15th to January 15th. And then maybe we'll allow lights from October 20th to November 5th to accommodate for Halloween. And maybe something around July 4th. Those are kind of the big events. And then you would have another rule that talks about any other time, the only lights that you're allowed to have are going to be white lights. That's kind of what we're talking about with religious issues. If you are in a condominium, there was a law that was recently passed that allows you to put a religious symbol on your door. So whether that's a, how do I say that, mezuzah or a cross, those things would be allowed in condominiums. They would not necessarily be allowed on a single-family home. But ultimately, that's kind of what we're talking about. Ultimately, you want to treat, I mean, we've had people that were devout Catholics and were burning their prayers out in their yard, and that became an issue because of fire concerns. So ultimately, when you're dealing with something like that, you have to look at it from the broader standpoint of we're not allowed fires. It's not that you can't burn your prayers, it's that you can't have an open fire in the middle of your backyard. Something along those lines. So you want to make sure any rules that we're creating are content neutral, that are not specific to one religion or another religion. Another thing that comes up is sometimes...
I got a question.
Yep.
So if HOA didn't have a policy, I heard of somebody putting lights up, and it's becoming quite frequent in our neighborhood. Are they kind of grandfathered into doing whatever you want with their lights, or can you retroactive a policy?
So, twofold kind of to that. If we're talking about like decorative light, like string lights, those are going to be harder to enforce against. If we're talking a physical light that's put on there, almost all of your documents are going to define that as an improvement. And so the owners would have needed to request permission from the association for any type of improvement before they put it up. So there may be grounds there. In terms of color of the lights, just like, so kind of twofold. If you were to just create a rule, it's going to be harder to force people that have already been doing it to stop. If you amend the covenants, and so that would require 67% of the homeowners, that's going to be kind of a drop dead. And anything that was in the past doesn't necessarily matter. They would have to comply going forward. So it's going to somewhat depend on how you attempt to address it.
You don't burn the lights on the eve of the roofs.
Like those like jellyfish lighting or whatever they're called. Those have been hard to enforce against. What we have been able to do is create rules that would say, again, you can only have white lights during this time of year. You can have colored lights during these other times of year. So they can set them to just white during this time and then colored during the time that they're allowed to. But they have been somewhat of a gray area. The jellyfish lights have been difficult because they're expensive to put in. We can also put, one of the other issues is how bright they are. Almost all of your covenants are going to have a nuisance provision. And so we probably have the ability, if they are excessively bright, to make them dial that down a little bit. Some of them that are flashing and are on like sequences, it's another thing that we can probably dictate via rule that you can't do that. You can only have them solid white, etc. Another issue is clubhouses. If you are renting them out and you're allowing a Catholic group and not a Jewish group, that would obviously be discriminatory. If you're going to allow any religious group, you need to allow all religious groups. And ultimately, it's just a classic, you want to treat everyone the same. I mean, a lot of this is just basic common sense. Ultimately, you're always going to have, in every association, there's going to be at least one homeowner who bucks the trend and wants to do whatever they want to do. This is my house. I can do what I want to do. Ultimately, when you're dealing with any of that type of stuff, it's why it's important to make sure you have a covenant enforcement policy. Not only is it mandated by state law, but it's also something that's good practice. But just having one isn't the key. You need to have it and then follow it. So any violations that are taking place, you need to go through those steps with all homeowners. Once you start picking and choosing what covenants or rules you're going to enforce, that makes it much more difficult to enforce once you have that problem owner that is going to show up regardless. And problem owner is maybe not the right word. The owner who is more individually inclined and less concerned with the community, that is going to be in every association. And so that's always something to consider. You got to make sure you're going through your enforcement policy with everything. Yes?
You forgot to say that owner is always living next door to a board member.
It's true. It does seem to happen that the troublesome owner, whether because it is a board member that is hypersensitive to their neighbor or whether it is actually that owner, it does tend to pop up a lot with neighbors of board members, unfortunately. All right, disability request for reasonable accommodation or modification. So first thing we have to determine is whether an individual has a disability or not. It's important to realize with the FHA that disability is broad. Allergies could be a disability. It's not just a physical impairment. It's not just a mental impairment. It can be a whole wide range of things. So the first step is we got to determine, does the individual have a disability? The next question that we can ask is the accommodation necessary to afford equal opportunity to use and enjoy the premises? And the third question is the requested accommodation reasonable? So it's important to know, these are kind of the only questions we can ask. These are obviously private matters, and so the association only has so much detail that it can get. If someone has a visible disability, we don't have the ability to ask them for medical documentation around that. If someone has a mental disability, we do have the ability to ask for a letter from a medical provider. Doesn't need to be a doctor, but some medical provider that can confirm that the individual is disabled pursuant to the FHA. And then there's got to be a nexus between what it is they're asking for and what their disability is. So if an individual has multiple sclerosis, but they want an ESA because of some mental issue or something, not even a mental issue, but they say it calms them. That's not related to the MS, so there's no nexus there. On the flip side, if someone has MS and they need a ramp to be put in or something along those lines, there is a nexus between the disability and what the accommodation is. So those are the things that we're kind of looking for. I mean, I don't know if you guys are board members or just owners, but anytime, and I don't mean just owners, but if you are owners or board members here, anytime your association gets a request for an accommodation, we always recommend it go to the attorney. These are somewhat technical issues, and they carry with them large liability. It's not uncommon that if an association denies an accommodation and the courts find that it should have been given, that an owner is awarded $500,000 or $1 million. That's a big special assessment to the association. So these are things that you want to get in front of the board and then in front of the attorney as fast as possible. Yes, sir.
Can someone just go ahead and put something in that accommodates a disability without going through the board for approval, even if it's against the bylaws or covenants?
So someone can do anything. In terms of what the board should do in that case, if someone with any improvement, whether it's for an accommodation or not, if once the association recognizes that something has gone in without approval, you should go through your enforcement policy, which the first step would be a courtesy notice. Ideally, once you've sent that courtesy notice, the owner will respond and say, I put this in for an accommodation. At that stage, we would ask those same 3 questions. What is the disability? Not what is the disability, but is the individual disabled? What is the modification that they're asking for? And we already know that. And then what's the nexus between the two? So the analysis is still the same. The fact that they put it in before doesn't mean that we can then deny it and force them to remove it if they're actually entitled to it. But we still need them to go through the proper steps so that 1, the association has documentation as to why this is there. And 2, we're confirming that there is actually a disability and a need for whatever this change is.
It sounds like the proof of disability is pretty loose. If all I have to do is come up with a doctor will write a letter that says you have a disability. Is that because of HIPAA, or are there other situations where you can ask for some real proof?
So the main purpose again of the FHA is to make sure that everyone can enjoy their house in an equal manner. So the standard is, I'm not qualified to determine if someone has a medical issue. Typically, board members don't have any qualifications, and they wouldn't, even if they're a doctor, they haven't examined the individual, they don't know it. So typically, the response is if a doctor is willing to put on paper that this individual is disabled and they need this, the association should comply. Yes, sir.
So does each of us have an ability to kind of say what the modification looks like? Type of rent, that type of thing?
Yes and no. So the short answer is if someone wanted to put in a steel ramp or something, say a steel ramp, and that was $1,000 and the board wanted it to be concrete, and that's $5,000, the chances are we would not be able to tell them no, they can't put in that ramp. The association may be able to say, look, we recommend you put this in. If there's a difference, we'll cover the cost of that difference, simple along those lines, depending on how important it is to the association on the aesthetics. Now, if it's something that's rickety or something like that, I mean, there's obviously degrees to all of this, but typically, if they are putting in something that is functional and generally standard, then they'd be allowed to do it. Yes,
You talked about allergies. So if your neighbor smokes weed or cigarettes and gas, we can't enforce anything in that situation. Like get rid of the neighbor or tell them they can't smoke weed or a cigarette.
Yeah, I mean, ultimately, whether it's smoking or someone making curry or something along those lines, if we're talking about a single-family home, there's almost nothing you'd be able to do. If we're talking about a townhome or a shared wall environment, what the association would be looking to do is make sure that any association maintenance responsibilities such as HVAC and sealing and things like that are all working. That's what you'd want to do, but we don't have the ability to prohibit someone from doing that. I mean, you could have if you were to get the association to adopt a amendment to the covenants of a no smoking, that would be something you could enforce, but that's pretty rare. Typically, the only time you're going to see that is on common elements, not in a private residence. Yes, ma'am.
If somebody needed this ramp or maybe a sidewalk extension to the street, is that at their expense or is that at the HOA's expense?
So we'll touch on that a little bit later too, but with a reasonable modification, that is typically going to be the homeowner's expense. There is that changes if it is, so say it's a multi-family unit and this is something that multiple people would use. If multiple people are using it, then that's probably going to be an HOA expense. If it's just for one individual, that typically would be the homeowners. Yes, sir.
So you were talking about elements and we can't do this or smoking, that type of thing. Our covenant says we can't go on.
Okay.
And it's legal all right.
Mm-hmm.
Is that right? Have that in there?
So just like with anything, I mean, it's legal in Colorado to paint your house any color you want, but the declaration can limit what colors you can paint. So it's the same thing, just because it's legal, so chickens is a good thing. Chickens are often carved out in declarations as not being able to have them, but in a lot of municipalities, they are allowed. So the association has the ability to have stricter rules than what a local government would have. Yes, sir.
Do the rules apply to tenants?
So-
From the covenants and stuff, that we're starting to get some absentee landlords and
So the,
properties kind of going south.
yeah, so the owner is the only one who is subject to the declaration. So if a tenant is violating something, the violation goes to the owner, and it's the owner's obligation to remedy that violation. You wouldn't want to send something to the tenant unless the owner has authorized the association to send something to the tenant, because then you're running into tortious interference of a contract.
There's nothing you can send to the tenant on entry, what's expected from a government standpoint, so.
So the owner is the only one who's responsible, who is bound by the governing documents. Now again, we are constantly enforcing against landlords, whether it's a national corporation or it's just an individual who's chosen to rent out their unit. They're still the ones that are responsible for it. So the process doesn't change. It's just the owner has the obligation to force their tenant to come to compliance. Yes, ma'am.
Question, in regard to a ramp that might be in the garage, a slide ramp to bypass the step and come to the garage, would the same procedure, I mean, from the garage to the drive, would the same procedure be true? You have to get permission from the engineer?
When you say garage, you talk like a single family? How it's inside the
I'm talking attached unit.
is the garage. So if the garage is a limited common element, then there's probably something that says you can't modify the limited common element without approval from the association. If it is like a townhome and the individual owns it and the association doesn't have any control of the garage, then just like any other modification you make inside your house, you would make it.
I've got a question.
Yes, sir.
Suppose the reasonable accommodation requires something that goes into the common area. Is that going to be all right? I mean,
Yep, so that's still going to be all right, depending upon what it is and what the use is.
but suppose you have someone who the VA has said this person has medical and emotional issues and requires a service dog.
Mhm.
But this person cannot walk the dog and is requesting an enclosure outside the back door so that the dog can go outside on its own and then come in, because the person can't walk the dog.
Yeah.
But it's going to encroach on the common area to build this pen.
So all of these are very fact specific. So like with something like that, I would highly recommend you reach out to your attorney. Just on a general note, I would say if you are carving out a piece of common element that now only one owner has access to, or one owner's dog has access to, that's probably unreasonable. There may be other accommodations that we would need to make, but in my mind, carving out a portion of the common elements that is meant for everyone to enjoy, for only one individual to be able to enjoy, is not treating that owner in the same manner as everyone else. That's giving them an extra benefit. When again, the purpose of this is to allow them to enjoy their home in the same manner as everyone else. But again, that's not legal advice. That's just in general what I would say.
Thank you.
All right, so what may be asked about a service dog in another place? So service dogs are only under the purview of the ADA. And a service animal can only be a dog or a miniature horse/pony. You see the horse/pony a lot with like therapeutic type treatments. In terms of the service animal, so first, is the service animal required because of a disability? Then again, what work or tasks has the dog been trained to perform? So one of the key differences between a service animal and emotional support animal is the service animal is actually trained to perform a specific task for someone who is disabled. An ESA is not required to have any type of training. It's not needed to do any type of task. So that's one of the huge differences. Anytime, I shouldn't say, if an individual actually has a service dog, a lot of people try to pass animals off as service dogs, but if an individual actually has a service animal, and they're on premises and the association reaches out to them saying, hey, you can't have your dog here, etc., they are almost always going to have the backup documentation to give you almost immediately. The individuals that are stating it's a service animal, and it's really not, they are the ones that typically are going to fight you. They might produce something from an online site that shows this is nationally registered service animal. There is no national registry for service animals. That's just you type in numbers on an internet page, you pay them $100 and they send you a certificate. That's not going to be something that complies. But typically when you're dealing with a service dog, one, you're going to know because they're extremely well trained. They're not going to go up to anyone. They're going to be by their owner's side. They're going to be attentive to their owner because they're there to serve an actual task. We rarely have any issues with service dogs. Where we do get into issues is with PSAs. But as you guys as board members or members of the association, people are often either intentionally or inadvertently stating that this animal is a service animal, when in fact it's probably an emotional support animal or not. All right, so under the FHA, when we're talking about ESAs, again, we have the ability to ask for that reliable documentation of the disability. That doesn't need to come from a doctor, but from a medical professional. Again, what accommodation they need and how the accommodation relates to disability. And again, you can only ask for documentation of a disability that is not visible. So you wouldn't ask for documentation of a blind individual or someone in a wheelchair. Those are readily available for you to see that these individuals have a disability. All right, disability definition. Physical or mental impairment, which substantially limits one or more major life activities. It can also be a record of having such an impairment or being regarded as having such an impairment. Major life activities. This is caring for oneself, performing manual tasks, walking, seeing, hearing, breathing, learning, working. Eating also is included under the ADA. So again, just to think about this, disability is much broader than what we tend to think about on a day-to-day basis. It's not just the individual in a wheelchair, it's not just the blind person, it's a much larger subset of individuals. Being regarded as having a disability is a covered entity mistakenly believes that a person has a physical impairment that substantially limits one or more major life activities. Or a covered entity. So covered entity just means the association for our purposes. So an association mistakenly believing that a person has a physical impairment that limits one or more major life activity, or the association mistakenly believes that an actual non-limiting impairment substantially limits one or more major life activities. It's very rare that we're going to come into anything along these. Sometimes you will have, this really comes up more in the employment world, where someone believes that an individual can't do more than they can do, and then will prohibit them from doing more things because of that. That's really where you see this. It doesn't come up in the HOA realm very often. So again, vast range of handicap/disability. It could be orthopedic, hearing, mobility, speech, visual impairments, CP, autism, epilepsy, muscular dystrophy, cancer, heart disease, diabetes, chronic alcoholism, chronic mental illness, AIDS-related complex, mental retardation, diabetes, autism, epilepsy. Apparently we thought we'd put cancer on here a second time, and heart disease. And autism. But you get the general idea. I can tell you I've had one with allergies. So we had a community where you weren't allowed to have hardwood floors. And the individual had extremely bad asthma, and the carpet was trapping the allergens. And so they needed a reasonable modification to allow for hardwood floors or some type of flooring that would not trap those allergens. So if the allergies are bad enough that they affect a major life activity, that can be a disability as well. So one thing to remember is that the law not only applies to the disabled person, but also persons associated with them. Also applies to those recovering from substance abuse addictions, but not to current users, as we touched on previously. Title VII extends to a handicapped buyer or renter, any person who will reside in the unit, or any person associated with the buyer or renter. So if you have a person who's living in the unit and their mom is coming over and the mom is in a wheelchair, we might have to create a modification for that or some type of accommodation for that. Again, it does not apply to, when we talked about substance abuse in the past, it does not apply to someone that's currently using, but for a rehab facility they are considered to be disabled under the law. We do run into a fair amount of times where it is a mom or someone who is staying with the individual long term or something along those lines that needs it, and the board knows that the individual living there is not handicapped and they are hesitant to allow a modification. That's a very tricky situation. It can get the association in a lot of liability. So again, anytime you are getting any type of request for a reasonable modification or a reasonable accommodation, you really do want to get that to your attorney as quickly as possible. There's another slide here that we'll talk on a little bit later. But if you delay granting that accommodation or giving a decision, that is seen as constructive denial, and so that can lead to liability as well. So these things have to be addressed in a quick manner. If your board is only meeting once a quarter, that's probably problematic. You're going to need to have a special meeting or something along those lines to come and discuss this and decide, is this something we can approve or not approve?
Does the same rules apply to limited common elements as apply to the common elements as far as accommodations?
So typically, when we're talking about accommodations, we're talking about changes to a rule. When we're talking about modifications, we're talking about actual physical changes. Typically, when you're dealing with something on an LCE or a general common element, you're dealing mostly with a modification. But it doesn't change the fact if an individual needs it to be able to use that, they can still make that modification even on the common elements, whether it's general or limited. You sometimes will have, maybe it's a individual who needs a service animal, and the individual doesn't have the ability to hold a leash, and you have a rule that says all dogs must be on leashes. In a situation like that, you'd probably have an accommodation to the rules that says this dog does not have to be on a leash. It still has to be under control, still has to be next to you, but you probably have to grant an accommodation on the general common element for that. Yeah, did I see two more hands back there or no?
Well, I'll talk about the linear approving the modification. We have 30 days to approve a request.
Yes. So the short answer is 30 days is probably the extent that you would have. But it's two different so this is trumping your general design guidelines. This is something saying you have a rule that's prohibiting this. I need this. So it should take priority over a general, I'm putting in a fountain in my backyard and I'm getting approval. All right, FHA documentation. What is reliable? Doctor recommendation, medical records versus a note, other forms. Ultimately, we can't require an owner to fill out any specific form or their doctor to fill out any specific form. Oftentimes, we will recommend that an association adopt a reasonable accommodation or reasonable modification policy that outlines the questions we can ask, that provides a form that they can use. Sometimes boards confuse that form as something they can use versus something they're required to use. Ultimately, all we can do is request the information. However that information comes in is fine. Again, it doesn't have to be an MD that provides it. It could be a psychiatrist. It could be a registered nurse. It can be all sorts of different people. Someone that is actually seeing this individual as a doctor, as a patient relationship with them. Those are things that are reliable. We don't get to, back to your kind of question earlier, we don't get to dissect whether we think the advice they're giving is right or wrong. Ultimately, it's if they went to a doctor and the doctor prescribed this or says this is something that you need, that's something the association is going to have to rely on and go forward with it. I mean, if you really wanted to challenge it, we've had some, especially with emotional support animals, we had an individual out of California who was basically, you write into the website, you pay them $100, they provide you with written documentation saying this person needs an emotional support animal. With that specific individual, we were able to track down and show, look, this person is never met this individual. They've never had anything. All they've done is filled out an online survey. They did not actually have any type of doctor-patient relationship. And so we were able to fight back on that. But it's risky. And it's something you want to look at on a case-by-case basis. But typically, any information that's coming from a doctor, and the doctors are, generally smart about it. They're going to say, look, this person is a patient of mine. I have met with them. It's my opinion that this individual is disabled pursuant to the FHA, and it's my opinion that this is the accommodation that they need. If that's the information you get, more than likely, you're going to have to grant the accommodation.
So can you ask the individual asking for the modification if you can contact that physician or that provider, medical provider? Are you allowed to do that? If they give you a note, it could be from some chiropractor down the road, so.
Yep, so I would not recommend it. Oftentimes when we get these letters in, the doctor will say, if you have further questions, feel free to reach out to me. So I think in that scenario, you could certainly reach out to them. But you're going to get a very limited answer to them. Ultimately, they say, yes, this is my patient, and this is what I think. So I would not, typically I would not be, the hill to die on is typically not going to be on the doctor's letter. All right, evaluating requests for accommodations. What is reliable documentation? So obviously online letters are a problem. People pay a small amount of money to get a document and then claim to be disabled. Secretary Ben Carson challenged HUD in November of 2019 to address this problem, and this is what was added to the HUD guidelines, which is what you can see on the screen up here. On a side note, HUD has issued a couple of different guidelines on these things. One is specific to animals, and then there's a specific one on reasonable accommodations and a specific one on reasonable modifications. They are roughly 20-page documents. They do a great job of giving examples of example A, example B, and kind of walking through general run-of-the-mill reasonable modification, reasonable accommodation. They are a great resource for any board to go and look at, just to have a better understanding of what it is you're looking at. So if you just look up HUD animal guidelines, it should pop up in a Google search. Same thing, HUD reasonable accommodation. They're all relatively old with the exception of the pet one. That one was just in the last 3 years maybe. The other ones are back in, I want to say 2020 and maybe 2014. But they're all still applicable. They are a great kind of starting ground. What this is saying is ultimately just a certification from someone that can go and get it online is not enough, kind of what we just talked about. However, if the individual says that they have been seen by this person, and it can be telehealth is certainly fine, but as long as they're having an actual patient relationship with the individual, we're going to have to accept what they're taking. If it's just them filling out a form and then a certificate pops out, that's something we have the ability to change. Again, going back to that United States Service Dog Registry, there's all sorts of these kind of fake is the right word, but things that carry no weight registries. There's nothing to them. You simply type in information, you put in Fido's name, and out comes this as a service dog registry. Again, there is no national registry. This doesn't do anything for the association. If someone provides this to you, we're going to say, great, here's what we actually need, which is a letter from the doctor, a letter from a medical professional, what the request is that you're asking for, what's the nexus, etc.
Question.
Yes, ma'am.
How does that apply, though, that you cannot deny a person to say rent or lease a space if they have an animal and they say that that animal is an emotional support? And isn't it recently by state law you cannot deny that person right to rent?
So that's a good point. It's, I think, a little later on the slides, but ultimately, an ESA is not a pet. So the regulations would be a pet. You can't have a pet. An ESA or a service animal are not considered pets. So any rules prohibiting pets would not apply. So if it is an emotional support animal or if it is a service animal, they don't fall under any of the rules that you would have regarding pets.
And did you say emotional support animal was only a dog or a pony?
Service animal is only a dog or a miniature horse/pony. An emotional support animal can be any animal. I've had ducks, I've had snakes, pigs. I'm trying to think of some of the other more random ones. But any animal can be an emotional support animal. Ducks and chicks were one of the strangest ones. Pig is kind of a strange one, although there's been a fair amount of popular pigs that have come up recently. But ultimately, any animal can be an emotional support animal.
As long as they have documentation from somebody to say what they're at.
That this animal is soothing their PTSD or is helping their anxiety or whatever it is. All right, so evaluate request for accommodation. What's the request for multiple? What if there's a request for multiple assistance animals? So a service animal versus an ESA. So with service animals, it's more simple. Because service animals are trained for a specific task, as long as the service animals are trained for different tasks, you're going to have to allow those service animals. So if one is there to detect a diabetic from going into a seizure, and the other one is there to help with mobility or something along those lines, both of those animals would be allowed. With ESAs, it's more difficult because they're not there to serve a specific task. It's hard to quantify why you need two instead of one. So we have pushed back on that on several cases. Oftentimes when you see that, it'll be an association that has a declaration that says you can only have two animals, and they'll say, these two are my pets, and this third one is my emotional support animal. We've pushed back on that. The Colorado Civil Rights Division does not like our argument of pushing back on that, even though there's some pretty good case law across the country that says you can't do this. Our Civil Rights Division is more consumer-based, or less caring about the associations and more caring about the individual needs, I guess you would say. And so as you saw with the Kate case that went up to the Supreme Court, that got shot down, our Civil Rights Division probably crosses the line, but it's extremely expensive to challenge that. So for the most part, they get away with it. But it is what it is. But if you're having someone who's asking for multiple assistance animals, ESA specifically, we will try and get additional information. Again, give it to your attorney, and they can help walk you through the steps and evaluate whether or not you should or shouldn't challenge it. Yes, ma'am.
Okay, so what if you have city ordinance and HOA covenants that state you can only have 4 animals in your house, and you have 3 people and they each have 2 emotional support animals? Can they still have those emotional support animals, even though they're in violation of having more than 4 animals in the house?
So the association doesn't care about the city regulations. We don't enforce those. That would be up to the city to do. From the association standpoint, again, you're probably, if they're service animals, there's not going to be a question they're going to be allowed to have them, because they're not pets. Emotional support animals, you probably have a stronger argument. But if they can produce documents as to why they need each individual service animal, even if it's not going to be considered a pet that's subject to
But
those
if it
rules.
doesn't say pet, it says animal, not pet.
It'd be pretty rare for it to say animal. I don't know if I'm trying to think if I've seen a covenant that just says animal, it doesn't say pet, unless you're talking about like agricultural land. But I would still argue the same thing, that it's not going to apply. That the federal law is going to trump what your declaration says. And I would assume the city attorney would say the same thing, it's going to trump their city requirements, but I don't know. Evaluating requests. So, because a service animal or an ESA is not a pet, you can't charge any additional cost for them to have them. So, they can't, if you are some of the high rises in Boulder have a requirement that your dog, you have to pay $150 if you want to have an animal. You have to submit a stool sample so we can tell whose poop is who if it's not picked up, things along those lines. We don't get to charge those kinds of charges to an ESA or a service animal. Thank you. Said it about 20,000 times tonight. Ultimately, it's because, again, it goes back to the main purpose again when we're talking about the FHA or the ADA. It's to give this person the same ability to use their unit as anyone else. And so charging them extra for something that they need to be able to live in it the same way that anyone else wouldn't apply. Same way if we get a CCRD claim filed against the association and the association wins, in most cases, the association, in most lawsuits, the association has the ability to recover its attorney's fees. In a discrimination case, you do not have that ability. So any money that is spent on attorney's fees is coming out of the association's pocket, even if the association wins. Associations that have tried to put those attorney's fees back on that owner's ledger are then hit with another CCRD complaint for retaliation, and they lose that complaint because they have put these attorney's fees on there. You can require that they comply with normal pet restrictions, even though they're not a pet. So if you guys have a leash rule, you can enforce that, picking up after them. You can enforce that. The individual doesn't have the ability to pick up after their animal. They need to hire someone to do it. They don't get to just go leave dog feces all across the common elements. It has to be picked up. There's lots of case law that says they are required to pick up after the animals. The caveat to the leash rule would be if the disability doesn't allow them to be on a leash. But that's, otherwise your general restrictions will work. The other thing to remember is if this is a service animal, that service animal is allowed in a pool area. They're not allowed in the pool, but they are allowed on the pool deck. You can't make them go through a separate entrance or anything along those lines if it's a service animal. Emotional support animal does not get that same ability, but a service animal will. Excessive barking is another thing that whether it's an ESA or a service animal, you're not going to have it with the service animal. But with ESAs, if there's excessive barking, that's still something the association can enforce. All right, some practice pointers. So the applicant for a request, again, is not required to be the owner of the person in need of the accommodation or modification. You do not request medical information if the disability is obvious, and if it's obvious how the request for modification will contribute to use and enjoyment. The healthcare provider is not required to be a physician. Again, we want to respond to requests in writing and in a timely manner. As we talked about earlier, courts have held delay equals denial. If there's no request, there's generally no obligation to make the accommodation. However, if a verbal request is made, the association should follow through. Also, if an accommodation is obvious, it makes sense for the association to offer it. There's no magic words as to asking for an accommodation. So hopefully if someone says, hey, I need a ramp, and you see they're in a wheelchair, you should treat that as an accommodation request. It's the ones where we can't obviously see it that we don't have an obligation to ask if they're making an accommodation, so we could deny it, and then typically what happens is they make the request because maybe they don't want their medical issues to be out there or whatever. They make the request, it gets denied, and then they turn around 5 days later and say, I'm asking for an accommodation. So at that time, we want to go through the steps, make sure we get all the documentation. If they're entitled to it, they're entitled to it. Courts also have not allowed associations to hide behind technicalities. So if an oral request is made, respond, even if the response is simply to ask that they make the request in writing. So if they're at a board meeting and they say, hey, I want this accommodation, the proper step would be, please reach out to your manager or to the board of directors in writing and let us know what exactly the accommodation is so the board can consider it. That does a couple things. One, it shows that we're creating a dialogue with the owners and trying to be reasonable. And two, it creates a paper trail so we know exactly what's being asked and what the association is being asked to approve. All right, do not deny a request because of a related or unrelated violation at the time of the request. So if an owner hasn't pulled their weeds and they ask for an accommodation, don't hold up the review of the accommodation because they're in some other violation. Whether that's delinquent on dues or anything along those lines, treat them as completely separate entities. Typically, if there's other violations that are related to it, we would tell you to put those on hold until we've made a determination as to whether or not an accommodation is needed. Place all violation issues and requests on hold while the applicant obtains requested information, or advise that the fines will be removed if they are found to need the animal per FHA. So we had a case up in the mountains, it's probably 7 years ago now, where a tenant moved in, claimed they had a need for an emotional support animal. The board had a no pet policy. The board denied it. The owner, well, first the board didn't respond. Then the board ended up denying it 3 months down the road. The dog this whole time was still in the unit with the individual. The owner, the tenant, then moved out, sued the owner and sued the association. And the association, even though the owner was with the dog, or the tenant was with the dog the entire time, the association paid out $750,000 for failing to grant the reasonable accommodation. So these things have real dollars to them, which is why you want to get them to the attorney as quickly as possible. Applicants will not generally be liable for the cost of an approved accommodation. So again, if there's any costs that are associated with an accommodation, that's not something the individual requesting is going to be responsible for. Different from a modification, if they're making a physical change, most likely they're going to be responsible for those modifications unless it's something that's going to benefit more than just that individual unit owner.
Could you differentiate, I mean, so is an accommodation usually regarding a service animal or an ESA versus a modification of physical change?
So an accommodation is going to be for any rule that the association has or covenant. So if it is, you're not allowed to have pets and they need a dog, that would be an accommodation. If it is, I need some type of physical change, I need a hand railing or I need a ramp, those are going to be modifications. And so modifications are typically going to be the association's, not the association's responsibility, or any costs associated with an accommodation. The kind of gray one is parking spots. So if you have individually assigned spots, and this individual needs to have one that is handicap accessible, and they need a curb cutout or something along those lines, in my mind that would be a modification. However, the courts have deemed that to be an accommodation, and the association would have to pay for the curb cutout and painting and things along those lines. But that's the only one that kind of straddles the gray area. But any other modification is typically going to be a owner's responsibility. One other thing, so if you have started fining an owner for having a dog that or an animal that they're not supposed to have, and then they submit paperwork for an ESA, you can continue to fine, but you're going to want to let them know that if it's determined that this is an ESA, that will waive the fines. We want to make sure we put that in writing so that they can't claim that we are coercing them or anything along those lines. So the board needs to be aware that if we do determine this is an ESA, that we're going to remove those fines, and we need to let the owner know that as well, or whoever the applicant is. All right, service animals versus emotional support animals. Again, neither are pets per the court. ADA service animal is trained. Service animals are allowed in restaurants and other public places. ESAs are not. Service animals defined by Title II and Title III of the ADA. Again, it means only a dog or a miniature horse. They're individually trained to do work or perform tasks for the benefit of an individual with a disability. So you see a person that's walking around in the supermarket carrying their dog, it's probably fake. It's probably not a service animal. Service animals provide a service to their owner, such as guiding a blind person or helping someone who's unstable walking, or trained to pick something up that's dropped, etc. A trained animal is 99% of the time on a leash of some sort. When you see animals in public misbehaving, it's a pretty big sign that they're not going to be a service animal. They're very well trained animals. You rarely ever have a problem with a true service animal. They're trained, they're meant to do a certain task. Those aren't your issues. It's usually going to be ESAs. ESAs are not trained unless the law allows them in the person's own home. Condos are required to allow ESAs or service animals in any place that the owner would be allowed to go, with a few exceptions. So make sure any rules apply to animals, not pets. We want to revise all policies to refer to them as animals. This is all technical. To be honest with you, I disagree with another one of our covenant attorneys who would say that by calling it an animal, we can create more rules on them. Ultimately, I think the federal law is pretty clear that if this animal is there to support them in some way, especially a service animal, you're not going to be able to put limits on that, whether you call it an animal or a pet. But it is great, and if the board ever wants to spend hundreds of thousands of dollars to challenge it, they certainly can. All right, there's one twist to Colorado law. Service animals in training are considered to be a service animal by default. So even though they aren't fully trained, they are still treated as a service animal as long as they're in training. An animal that's being trained as a service animal and a trainer of a service animal are entitled to accommodations. So if you have someone who is training service animals, they are going to be allowed to have those animals in the same way that a disabled person would have. The trainer does not need to be disabled. And I've only seen that come up once, where we were having a fight over whether or not this person was actually a trainer or just trying to get around it. But again, when you're doing the training of the animal, it's usually an 8 month to year process. So once it gets past that, you have a much better argument that they're no longer a trainer. But it has come up. All right, reasonable modifications. So requests for modifications follow the same course as accommodations. Is the individual disabled? Do they need what they are seeking? And you can make them submit plans to obtain approval. Cost is on the owner seeking modification. Again, there's a caveat to that in terms of if it's going to be used by more people than just that one individual. Sometimes the modification is on HOA property, sometimes it's on owner's property. You can make sure it's aesthetically pleasing and well built, but you're not going to have controls over exactly what material they're using, etc. And ultimately, if it's going to cost more, then you're probably not going to be able to enforce that or require that they put on something that's more expensive. Yes, ma'am.
Can I ask a question about
Of course.
Amendments? If you have to make an amendment to allow a service animal or something like that, can the board alone do it, or do they have to have the 68% of all the owners agree on this amendment?
So this wouldn't be an amendment to the declaration. This is an accommodation to an individual. So you're not amending the declaration to say John Doe is allowed to have a dog. Ultimately, you're granting an accommodation to the rules that are in place for everyone else that says this person gets that dog, so that they are able to enjoy the property in the same way as everyone else.
So the board alone can do that?
The board would make this decision.
And can you disclose that? If someone says, well, they get that animal, I cannot.
Yeah, so typically what we would say is they are permitted to have that pursuant to federal law. And leave it at that. I would not go into any more detail than that. So again, this comes up with ramp requests, sometimes elevators, sometimes parking spaces or curb cuts. We talked about curb cuts already. On parking spots, the CCRD will rarely rule against a request for a parking spot. There are limited times where we have prevailed on that, but typically if someone's handicapped and they need to be closer, and the association has the ability to make them closer, whether that's turning a guest parking spot into a parking by permit only and only handing out that permit to that individual or something along those lines. If we have the ability to do it, we're going to have to do it. Most boards their first response is, Jane Doe asked for this. I know of 10 other handicapped people. As soon as we give it to this person, they're all going to flood in and make the same request. That's not a reason to deny it. Ultimately, if the second person asks for it, then we give it to them. If we run out of spots, then there's no longer an accommodation that we can make. But we don't get to, the fear of an influx is not a reason to deny. All right, must make reasonable accommodations to allow full use and enjoyment of the premises. Deemed reasonable if it does not result in an undue financial and administrative burden or fundamentally alter the nature of the housing in question. So when we're talking about fundamentally alter the nature of housing in question, if an individual says, I'm homebound and I can't go get my groceries, it's not a reasonable accommodation to require the association to go get your groceries. Outside of things like that, or I need this dog, you guys have to come walk my dog, things along those lines, the owner is responsible for those aspects of it. Undue financial burden, it comes up from time to time. If an individual is asking for something that's going to cost the association $100,000 and the association obviously isn't prepared for that, that's probably an undue financial burden. But most of these things are going to be, one, on the owner to pay for, and two, typically have very little financial cost to them to the association. So typically that doesn't really fall under it. Administrative burden, the same way. I mean, you see them more in like a high rise where someone's asking for a support staff to do something that's outside of their job, and that might be an administrative burden and would be grounds to deny it. Question is whether reasonable accommodations will permit the disabled person to realize the full use of the premise. It's a question of fact. So full use means equal use to others, not superior use as we talked about earlier. Issues of financial burden is a future burden as the cost of a modification is placed on the requesting party. Applicant will not be liable for maintenance costs of approved modifications to the common areas. So if they put in a ramp and say that ramp is to get into the condo building, but the ramp itself is outside, the association is going to be responsible for the maintenance cost of it, but to actually install it would be the owner's responsibility. And again, that maintenance cost is because other individuals, anyone has the ability to use this. It's not like on someone's private property where it's just them using it. It's open for, it basically just becomes a common element, and so you have the maintenance responsibility for it. Determining undue financial and administrative burden. First, you're going to look at the financial resources of the association, the cost of the reasonable modification or accommodation, availability of other less expensive alternative accommodations that would meet the needs. A fundamental alteration of the housing is considered unreasonable. An example would be providing bus service to a disabled person who can't drive when the community does not provide such services. In most instances, modifications will be made by the applicant at his or her expense. Although generally HOAs are not subject to the ADA, associations should note that the ADA shifts the cost obligation to the association if any building or facility meets the definition of a public accommodation under the ADA. Where we see that most often again is in pools. And so if it is a pool that's open to the general public, you're going to have to comply with all the ADA pool rules. As we talked about earlier, some of the high rises downtown and things like that might have ADA application, but for the most part, it's nothing that you guys will ever want to cross. All right, what are we seeing when owners do not get their way? There's a couple actions they can take. They can take a CCRD action. Again, the CCRD is the Colorado Civil Rights Division. The benefit of a CCRD action is it's the state that's prosecuting. So ultimately, you fill out a online form to the CCRD. They take your information, they'll call you, have a discussion, and then it's the state or the CCRD that is actually bringing this claim. So there's no cost to the owner. So it's typically the first step when an individual believes they're being discriminated against is they'll go to the CCRD. CCRD actions are generally quick in a litigation perspective. They usually are 9 months to a year. You'll get the complaint. We only have 10 days from when we get the complaint to file a response. We will always ask for an extension. They usually will grant us a 2-week extension. Then we'll go to, if you have a management company, you have to collect a whole bunch of documentation. We put forth a response, and then it goes back to the CCRD, and you hear back from them in 6 to 9 months, typically, with the determination. Sometimes they will request an interview with someone from the board or the management company, and that'll happen from time to time. If they don't go with the CCRD action, or after the CCRD action is completed, they can file either a state or federal lawsuit. Potential outcomes when you're doing the CCRD, typically, they might issue a fine somewhere between $10,000 and $50,000, depending on what the violation is, depending on if the association has had other CCRD complaints. State or federal lawsuits, those damages are going to be much larger. They're going to be in the 6 figures, sometimes over $1 million. Pros and cons, what can the association really do? Ultimately, it sounds like my whole spiel is that the association really can't do much. The association still has the ability to do a lot. The main focus is that we need to make sure that we're only giving accommodations to those who actually need it. And so if they jump through the hoops and they give us all the documentation, chances are they're going to get it. We try to weed out anyone that is not doing the proper process. You still have the ability to enforce your other governing documents, your other covenants, these owners are still responsible for everything else. It just is, again, goes back to that fallback position of we're trying to allow this individual to enjoy their home in the same way that everyone else would. And so sometimes that means we have to allow them to not be subject to one rule for them to be able to have that same thing. All right, so going back to kind of the enforcer side of this. So HUD is the main enforcer of the FHA. They have delegated that right to the CCRD in the state of Colorado. HUD's mission is to ensure the access of every American to a decent, safe, and sanitary home and suitable living environment. The CCRC oversees the Colorado Civil Rights Division. The CCRD is the enforcement arm of the CCRC. HUD has certified the CCRD as a substantial equivalent agency. So the CCRD will deal with both employment issues as well as housing issues. Occasionally, an association will get involved in an employment issue if they have employees. So especially if you're down like in Highlands Ranch, they have a ton of employees, so occasionally they'll run into employment disputes. Most of your associations don't. Most of you just have agents like myself, like a contracted employee, not really an employee, a contractor that is not an employee, so you wouldn't fall under that side of it. But if you do have a big association or you have someone that is a full-time door concierge or something along those in a high-rise, something like that, you might see some of the employment stuff pop up. So who is the CCRD? CCRD is a government agency that enforces Colorado's anti-discrimination law. They work with the EEOC, so the Equal Employment Opportunity Commission, and the Housing and Urban Development. They investigate claims of alleged discrimination. Laughing at one of the notes of the other attorney who does the similar thing with me at our firm is a little more jaded toward the CCRD than probably I am. But they're easily seen to be a biased group. Whether you really want to call them biased or not, they are very dedicated to making sure that the individual is getting all the rights that they think they are entitled to. And so with that, they tend to come from the individual side, not the association side. Whether that's biased or not, I don't know, but it certainly is where they tend to lean, or at least where they start. They are also pretty good, however, at oftentimes the owners that are complaining, once you actually get those individuals talking to a third party, the more they talk, the more they dig their own hole. They tend to come across fanatical almost. And so honestly, the first position that the CCRD is going to take is generally going to be anti-HOA. Once we lay out our case, I probably handle 40 CCRD cases a year, and I think I've had the CCRD rule against me 2 times. Typically, the association is not doing anything wrong. It's just a matter of being able to document what we did, why we did it, and how we got there. So although they are geared towards the owner, they're reasonable people that understand the arguments, and they eventually typically get to the right situation. And honestly, those ones that have been ruled against me, there's been some that I would say the CCRD should have ruled against us, and they didn't. And there's been one case where they ruled against us where I think they probably shouldn't have. But ultimately, I think they generally get to the right rule. Again, if you want to look at why some people believe them to be biased, you can look at the Masterpiece Cake Baker case. The Supreme Court came down hard on the Colorado Civil Rights Division, so they're overstepping their bounds, basically doing all sorts of things they couldn't do. They then remanded it back down, and the CCRD immediately filed a new complaint against the baker. So there's certainly some issues in that. I have not seen it as much in the HOA realm, but you certainly could make that argument. All right, so the CCRC will conduct hearings on character, causes, and extent of illegal discriminatory practices throughout Colorado. So the general process of CCRD, we get that complaint filed by the homeowner. CCRD then files their actual complaint. They send it to the association. We file a response. Once you file a response, the CCRD is going to issue a ruling of either probable cause or no probable cause. If it's probable cause, that's saying probable cause that the association did discriminate against this individual. If it's no probable cause, then they're saying the association didn't do anything wrong. If you have a ruling of probable cause, the next step is what's called a conciliation, which is basically a mediation, except you are not dealing with a neutral third party. You are basically having terms of a settlement dictated to you by the CCRD. If you don't settle it at the conciliation, then you have the ability to have a hearing in front of the CCRC. And they will ultimately issue the final determination as to whether discrimination has occurred or not. It's pretty rare that you ever actually get to the CCRC. Sometimes we'll have a mediation as soon as we get the complaint. At that stage, if I think the association has done something wrong, I will typically reach out to the CCRD and say, let's get the parties together and have a mediation before we start this process and see if we can't work it out that way. Oftentimes we're able to get it resolved then. One of the requirements of that by the CCRD is typically they're going to make the board members attend a 1-hour class on fair housing. And then there's usually not a monetary side to it, but it's going to be here's what you need to do, whether you got to move their parking spot or you got to grant the accommodation or modification, etc. So usually if a board has done something without legal advice, we can try and head that off there. If we get to conciliation, we still can't agree, it becomes a much bigger issue, and that's when you get into the fines. But typically we're able to resolve it before then. It's still going to be a cost to the association, but it's kind of a cost of doing business.
Is this a timely process, or is this like the cosmic void?
Well, it's relative. In my world, it's pretty timely. I mean, it's not uncommon for a litigation case for me to last 3-4 years. A CCRD case is typically going to be wrapped up within 9 to 12 months. So in that realm, it is more similar to, I guess I would say, like a county court case, where it's going to be a little more, it's going to work at a faster pace, because they're not going to, the details, you don't get into as much detail. But that's ultimately what it is. The CCRC also advises the governor and General Assembly on policies and legislation. They review appeals of cases, investigated and dismissed by the division. So if the CCRD finds a ruling of no probable cause, the owner can appeal that to the CCRC. It's pretty rare that happens, but it does happen. They adopt and amend rules and regulations in the enforcement of the state's discrimination statute. So there are administrative rules that are set out for the CCRD. And so oftentimes we can try and get cases thrown out based on those rules. One of them is that the discrimination had to have taken place in the last year. If they are trying to go back longer than a year, that's outside of what we would commonly call statute of limitations. And so they wouldn't be able to enforce that. So there are some things that can help us when we're dealing with the CCRD. So things that we've kind of briefly touched on already, but CCRD complaints, the formal complaints are filed free of charge. Housing complaints must be filed 1 year from the date of the last occurrence in the discriminatory act, or the CCRD will not investigate the claim. CCRD drafts the charge. The charge is just the complaint and serves on the respondent, which would be the association. Typically, they're going to serve it on, they're going to name the association and oftentimes the management company. Occasionally, they will name an individual board member if someone has had a more hands-on experience with this owner. Regardless of that, typically what will happen, it will come to our office and we'll respond on behalf of all three because all the parties are united in their defense. Occasionally, if the management company acted outside of what the board wanted, then we might have to get two separate counsels, one to represent the association and one to represent the management company because there is a divergence between the interests, but that's not the norm. Respondents, again, the associations then get a chance to respond and provide information. Dispute resolution is highly recommended. Dispute resolution will just be that mediation that we were talking about earlier on the front end. The CCRD then does its investigation. The division director will make the determination. Then we have the conciliation and the right to appeal. Probably walk through all of that. So in the request of information, so when we get this in, and again, it's a very tight window, we're going to need to get all the governing documents from the association, any resolutions that are pertinent, any correspondence with the homeowner. We're going to need meeting minutes. We're going to need all the covenant violation logs, homeowner lists, any prior accommodation requests that have been requested, any prior discrimination claims, photos, affidavits. It's a huge amount of information. It's a big fire drill. When these come in,
my next 2 weeks are like shot down. All you do is, I'm going through documents, trying to have to pull everything. Ultimately, a lot of the CCRD complaints are going to be predicated on, we sent an owner a violation for not maintaining their yard. The owner is a individual in a protected class, whether that's a woman or familial status or a person of color, any of those things. They're going to say that the association is treating me differently. So we're going to want to get all the covenant violation logs to show, look, in the last year, we've sent out 142 violations. Yes, you received one, but 141 owners also received one. Ultimately, all of the stuff that we're gathering is to show that we're treating all individuals the same manner. So that's typically why we win, because 99% of the time, associations are treating everyone in the same manner. Occasionally, you do have conflict of personalities, and there might be a person that is getting picked on. Hopefully it doesn't happen, but it does happen from time to time. Obviously, if any of you guys are board members, highly stress that you don't do that. If you do have a personal conflict with someone, recuse yourself from the conversation. Document it in the minutes. Like, look, I have a personal history with this individual. I'm going to recuse myself from this decision making. And that way, when we're in front of the CCRA preparing our response, we're going to point to the meeting minutes where it says, Director John Smith recused himself because of a personal relationship with this individual. Things along those lines are very helpful for us in terms of trying to combat these types of issues. All right, so after the CCRD receives the information, request additional information. Those are kind of the interviews that we were talking about. The CCRD then issues its probable cause found or no probable cause found. We talked about if probable cause is found, the case proceeds to conciliation, and then it can proceed to the AG's office. If no probable cause is found, the complainant may still appeal to the CCRD, or they can file the matter in state or federal court. It's pretty uncommon for an owner to lose at the CCRD and then file a federal or state complaint. It happens from time to time, but you already have a governmental agency that said there was no discrimination, so it's pretty good grounds. It's also fairly uncommon for the CCRD to find probable cause, issue sanctions, and then the owner file a federal complaint even after that. They can. We actually have one happening right now, which is unfortunate. But I think we're going to have a better chance of prevailing at the federal level than at the CCRD level. But that is always, the owner always has that option. They don't have to go through the CCRD process. They have a year after the CCRD has made its determination to still file a federal complaint or state complaint. So it's always out there, but it doesn't happen that often. Most of the stuff that we deal with is going to be through the CCRD. Some of the big cases, like if we're dealing with a group home or a drug rehabilitation facility, those might go straight to federal court, but it's pretty rare in the HOA context. So the courts. The CCRD is not the only way the FHA can be enforced, and FHA is the same thing. It's just the Fair Housing Act and the Fair Housing Act amendments is why you see that delineation. Again, plaintiffs may go directly to court and bypass the CCRD in federal court. Because the FHA is a federal law, this will be a case in federal court. Anytime you're dealing in federal court, it's going to be really expensive. Extremely expensive. You're not going to be covered by insurance because it's a discrimination claim. I mean, you're going to be spending hundreds of thousands of dollars if this goes to federal law, if it goes to federal court. It's also going to take forever. Federal court system is extremely backlogged, and this is not a high priority case. Like, this is going to drag out for several years. So consequences if you lose. High cost. Anywhere from $1 to $1 million, can be higher depending on what it is. Even if you win, the association loses. So what we mean by that, when a CCRD complaint is filed against the association has already lost. You're going to be paying an attorney to respond to this complaint. Typically, you're only talking about $3,000 to $5,000 probably to respond to that complaint, but that's money that you're never going to see again. There's also time and aggravation. It can be a public relations nightmare. Oftentimes, in my mind, the ones that are least justified are the individuals that go to the news first. So it can be a public relations nightmare. You've seen it a lot. I mean, there's been a pretty good push against HOAs in the last 3 to 5 years, specifically with collections and foreclosures. And it all started with homeowners complaining. With the foreclosure, they probably had a legitimate gripe. There was one attorney out of Parker who was just immediately going to foreclosures. And really that's what set in line all of these changes that have taken place. And then Green Valley Ranch was really a misunderstanding as to how it was being enforced, but those two things together were a perfect storm, and that's why we've had all this legislation over the last 3 to 5 years. And the two representatives who are behind those pushes are still in office and are already talking about changes for next year. So it's not going to get any easier for HOAs. There's going to be more policies that have to be adopted. There's going to be more changes to law. It just is the reality that we're living in. At some stage, it's going to have to swing back, but it does not appear to be doing that as of yet. All right, prevention. So, as I've tried to stress a bunch of times, have legal counsel. Anytime you get one of these, get it to your legal counsel as fast as possible. From a proactive stance, it is good to have legal counsel review your governing documents for any discriminatory language. Again, if it's a covenant, that's harder to change in terms of we're going to need 67% of owners to approve it. If it's rules and regulations or pool rules or anything along those lines, those are typically going to be done by the board. So those are pretty easy to bring into shape. Your adoption of policy might require that you send it out to the owners for comment for 30 days, but it's going to be the board members that actually approve it. It is highly recommended that associations adopt a policy on reasonable accommodations so that there is a set format for boards to follow in terms of these are the questions we can ask, here's the information we need. It's very helpful to guide the owners into, ultimately, we want to guide the owners to provide us the information as quickly as possible so that we can determine whether or not accommodation is needed or not. One of the things that the CCRD is looking at is they want us to be working with the owners, not trying to combat them. So taking a cooperative approach versus a defensive approach is huge. Trying to work with the owners to find something that works for them and works for the association is very beneficial. Having that dialogue in and of itself oftentimes is one of our greatest defenses against a CCRD complaint. So we all have our own biases in terms of we often think that an individual is trying to skirt the rules. Coming at it from that approach is typically not the best. Trying to see it through what it is they're asking for, trying to talk to them, have that dialogue. Why do you need this? Is typically your best approach to trying to keep the association out of dealing with these CCRD and costly lawsuits. Always keep good records for all covenant violations, rule enforcement actions, requests for architectural approval. Again, we're going to use all those documents in our response to try and ensure that this individual is not being treated any differently. So good record keeping, it's just a general rule, is great. It sometimes becomes difficult when you're shifting from management company to management company. Sometimes things get lost. But ultimately, try and keep as good as records as you can. When you do switch management companies, make sure that they're transferring everything over. If you don't have a management company, make sure when you're switching from board member to board member that all those files are getting transitioned over. All those things are important because it's hard to recreate the wheel from 5 years ago if we don't have any documents. One thing to be careful about with those policies, again, as we talked about with the accommodation policy, is it might provide a form that people can fill out. You got to be careful with requiring that to be filled out versus requiring the information to be given. So as long as they provide us the information, it does not need to be on that form. We provide that form because we think it makes it easier for them to provide the information, but they're not required to use the form. Always be consistent in application of all policies. Document in writing all communications and decisions. Obviously be sensitive to requests by members of a protected class. And you guys are already here, but keep getting educated on the fair housing requirements. These are all great ways to help keep the association out of trouble. So the key to any review of any request in the court system is whether or not the HOA acted properly and had interactive dialogue. Did you take the time to talk to them about what they want and look for ways to get them something that would work for both parties? I mean, that's ultimately what we're trying to do. We're trying to get everyone happy. It's like a good settlement. Everyone might not be perfectly happy, but at least we're content with the solution. So that's what we're trying to do. We want to create that dialogue. We want to try and make it so that everyone can use their property in the manner that's intended to be used. How long is this class supposed to go? 8 o'clock. Okay. All right. We're getting fairly close. And then we can have some questions. All right, so practice pointers, again, document denials thoroughly. Remember that the law allows disabled persons to enjoy their homes to the same extent as those without disabilities. Be reasonable. Again, it allows them to use their homes in the same way as others. It doesn't allow them to get some type of an advantage. So ultimately, that's when we were talking about being able to rope off a part of the common area, fence in a part of the common area. In my mind, that's something that's superior, and so that's something that probably wouldn't be allowed. But that's what we're looking for. We want to make sure that people have the ability to enjoy their home just like any able-bodied person would be able to do. So some specific things that come up. Breed of dog. If you have a no pit bull rule or something along those lines, again, these aren't pets. So if an ESA is a pit bull, they'd still be allowed to have it. Those weight limits or breed limits aren't going to be enforceable with regards to ESAs or service animals. There's Texas and Florida case law on pit bulls. Even if the county prohibits, the association cannot. Ultimately, what that's saying is, look, association only can enforce its own rules. We're required to allow those things. If the county prohibits it, the owner would have to go sue the county and try and get the accommodation. Yes,
So
ma'am.
what if your insurance says, we will not insure you if you have pit bulls in your community? What do you do about that?
So that would be very specific. In general, I would say we'd have to look at all the different things that are going on. Arguably, we might be able to make the argument that this is something that would cost financial burden on the association because we're going to lose our insurance, and so that might be grounds to deny it. But you would not, as a board member, want to make that decision on your own. You're going to want a legal opinion telling you that you have the ability to do that, so that if you rely on that, you have protection for the association. Even if we're wrong, at least it's going to protect the association from.
One of the insurance companies are now refusing to provide homeowners insurance if they have a pit bull, but I didn't know how to work the HOAs.
I have not seen anything in an HOA insurance document that prohibits pit bulls. There's obviously a bunch of changes that are happening right now in terms of, especially in the mountains, like not having any type of grill on your deck or anything along those lines in condominiums. But I've not seen anything specific to a breed of animal. But again, it would be fact specific. So you can deny any, so say an individual had a dog, that dog attacked someone, and then they say, I want this dog to be an ESA, and they get a note. If a dog has already attacked someone, we would have the ability to say this is a vicious animal and disallow it. But we can't do that just based on the breed. It would have to be specific to that dog attacking someone. So that is one way that we have the ability to limit an animal. If the animal would cause substantial physical damage to the property or others, which cannot be reduced, it's going to be a hard thing to prove. Ultimately, just being a big dog doesn't mean that it's going to be any more destructive than any other animal. But there are other ways. I mean, again, this is all fact specific. This is why you want to get it to the attorney before making any determination on a reasonable accommodation. Again, they are required to clean up dog waste. If they can't clean it up, they need to hire a service to do it. There's a Connecticut case involving a mentally disabled defendant. The owner was not cleaning up the waste. The association was able to evict for this reason. So they were able to get the tenant out because they weren't cleaning up. That is a unique situation in terms of evicting as an association. Typically, associations don't have the ability to evict, but oftentimes we can force the owner to evict. Illinois case regarding leashing, and we already talked about this a bit, but ultimately, if you have a rule that requires animals to be on a leash, those still apply to the ESA or to a service animal unless the owner doesn't have the ability to keep them on a leash. So again, fact specific, but we do still have abilities to limit these animals, and especially in common areas. Delaying granting accommodation, again, we talked about this, but you need to make the action fast. If you don't take action quickly, it can be deemed as a constructive denial, in which case the association is discriminating, and so you're opening the association up to liability. So one of the important things is that there has to be a nexus between the disability and the accommodation. I know we talked about it briefly, but if the owner has a note from a medical professional stating that the animal helps with anxiety and the disability is MS, then we'd probably be able to deny the animal because that's not, the two are separate. The dog isn't doing anything for that. However, if the disability is PTSD and the dog helps with anxiety, then the animal would be allowed. So all these things, again, fact specific, but there needs to be a nexus between what the disability is and what the accommodation being requested is. Specialized training, so unlike service animals again, ESAs need not have any specialized training. All that needs to be shown is that the animal must facilitate the person's ability to function. So again, if they help with anxiety, if they help with calming someone down, all of these things, those are typically what ESAs are used for. And while ESAs do certainly get abused, there's not a whole lot that we have the ability to try and show that someone's lying about it. There is a specific statute in Colorado that states if an individual lies about an ESA, they can be both held criminally liable and civil liable. So if we have a case that we think is questionable, oftentimes we will respond back to that owner with that specific statute and see what the owner does with it. Sometimes it works, sometimes it doesn't. I mean, again, it's hard for us to know whether or not someone actually needs it. That's why we have to rely on the medical advice. All right, competing disabilities. So we kind of talked about it with parking spaces, but it can come up in lots of different ways. This case was an Ohio State University sorority case. A woman had an emotional support dog. She moves in. A few weeks later, another woman in the house complains that she's allergic. So we have two different competing disabilities. Which one outweighs the other? Typically, it's going to be first in time. So if I requested my accommodation first, typically that's going to be the one that controls. In this case, they sided with the second person. The individual had Crohn's disease because they said they applied to live in the house first. However, they didn't state that they had a disability. So that's why the court overruled the Ohio State decision and ultimately said it was, since this person stated their disability first, that accommodation came first, that's who gets to have the accommodation. You see this a fair amount in pet-free condominiums where people specifically move in there because they are allergic or things along those lines. So it does come up a lot in that. It is always a tricky case. We try to work with both sides to see if we can come up with some type of accommodation that suits them both, but it's a difficult thing to try and deal with. Competing disabilities is always problematic. Again, ESAs don't have to be dogs. We've seen cats, chickens, ducks. Almost any animal can be an ESA if it's helping with an owner's ability to function. Again, service animals must be dog or miniature horse. All right, into some meeting stuff. Complete switch up. I'm not exactly sure how this got put together, but we are going to talk about meetings. And again, I do litigation. I don't really do that many meetings, but I will walk you through this to the best of my ability, and hopefully you guys have more questions about the FHA and less about meetings. All right, so two different kinds of meetings. You have a membership/owner meeting, and you have board meetings. Your membership and owner meetings are going to be your annual meeting, special meetings that are called, budget meetings, your budget ratification meeting. Those are all going to be membership/owner meetings. They can be virtual or in person. Board meetings are going to be your regular meetings. You might have a special meeting, a working session. There really is no such thing as a working session. Ultimately, anytime the board is getting together to discuss association matters, that's a board meeting. It should be properly noticed. It should be open to the public, to the membership. Sometimes the board will call special meetings, so that's why it can still be a board meeting. But again, those can be virtual and in person, but there is no such thing as a working session. Oftentimes, boards like to get together and they want to come up with their plan of attack. There's nothing that allows for that in the Nonprofit Act of Iowa. So ultimately, if you guys are doing that, that is probably something that should be open to all of the members of the community. You can have email. So you obviously can do things outside of the meeting. You have emails going back and forth. If you take an action outside of the meeting, those emails that are related to that action are discoverable or open to the membership. But if you're looking to have a conversation as the board about association matters, that should be a public meeting. You have a question?
Yeah, Do you have to notify all leaders?
So you can post on the website, you could send an e-blast. Typically, there's going to be a calendar that shows all of the meetings, something along those lines. If you are having a meeting outside of the regular meetings, you should update the calendar. I would advise, more information is better. I would highly advise you send out a e-blast sending, hey, we're going to have a meeting here, here's the time, here's the location. If we're doing it via Zoom, here's the Zoom link. But providing that notification is always in your best interest. Yes, sir.
What if you have a sensitive matter that the board should be discussing by themselves, such as if you have a lawyer and you're in litigation with one of the people and we have to have a meeting and it's quite sensitive, is that still have to be listened?
So we're going to see a slide about that in a second, but that's an executive session. There's 6 reasons why you can go into executive session, but talking about legal advice is a reason to go into executive session. So typically what you would have is you'd have the board meeting, and then you'd go into executive session. Or if you're just having an executive session, still would be technically a board meeting. The board meets, you go into executive session, and then you come out of executive session. Yes, ma'am.
So as far as like the board prepares the budget and the ownership doesn't even ratify it anymore, they just don't into it. But while working on the budget, I've seen associations do like working sessions to work on the budget together. Should homeowners be invited to those as well, or no?
So again, there's no such thing as a working session under Iowa or the Nonprofit Act. So yes, I would say that. I mean, again, the board's not doing anything. They're not trying to do anything discreetly. I mean, ultimately, like, we're having decisions. If homeowners want to come and listen to, here's why we're allocating $10,000 here and $15,000 there, there's really no reason why a member of the association shouldn't be privy to that information. In practicality, it never happens, but that's what should happen. Yeah. So you can have, it can be virtual or in person.
Are we required to offer it virtually?
There's no requirement to offer it virtually. I mean, since COVID, a lot of communities have gone virtual. Some have tried hybrid. Unless you have good technology, the hybrid is fairly difficult. But yeah, I mean, ultimately, there's no requirement. There's been a push to say that you can't have virtual, but I haven't seen it contested in court, and honestly, I don't think it would fly. All right, so meetings in general. So each type of meeting, your governing documents that are going to set forth your bylaws typically are going to talk about how meetings should be conducted. So each meeting might have different notice requirements, might have different voting requirements, different quorum requirements, what decisions can be made at different types of meetings, owner participation. So at the board meeting, owners can't propose something at a board meeting. They certainly can, before a decision is made by the board, we open it up to the floor and they can make comments, but they don't get to add to the agenda. Typically we're having an open forum, so they can have that. If they want to get on the agenda, they can certainly reach out to the management company and we can create a specific agenda item to discuss something. But in the meeting, they don't get the ability to dictate how the meetings go. That's the board's purview. That's what they get to do. At the owners' meeting, it's different in terms of the owners are actually the ones making the votes. The only thing you can vote on, though, at an owners' meeting or at a special meeting is what's been laid out in your actual agenda. So oftentimes, if there's contentious things going on, owners might show up and they're going to demand, we want to have a vote right now on X, Y, Z, and if that's not on the agenda, we can't have it, which obviously doesn't make them particularly happy. But ultimately, typically what would happen after that is then we'd call a special meeting for that specific, whatever the vote is that needs to take place, if one needs to take place. Whether it's a recall meeting, I just had one of those last week. All of these things, but the agenda is what dictates what's going to be talked about at an owners meeting or at a board meeting. And again, those notice requirements might be different for a board meeting versus a owners meeting. They probably are. Your voting requirements are probably going to be different. They're definitely going to be different. I mean, at the board meeting, it's just the board voting. Quorum also may be different for different types of meetings. So if you have a recall meeting, you might need 20% of the community to be quorum, whereas an owner meeting might only be 10%. All these things are specific to your governing documents. Yes, sir.
So if I understood you right, you can't add items to the agenda of an owners meeting like you can sometimes at other meetings where you give the opportunity for people to add items to the agenda.
So at the board meeting, the board has the ability to amend the agenda as it sees fit. At the owners meeting, you're going to have a tougher time doing that because you only have that certain subset of owners that are there. And so if you were to change the agenda to vote to change something else, all the other owners that looked at the agenda and said, this is what this meeting's about, and I looked at it, I chose not to come to the meeting because I didn't care about what they were talking about there. And then all of a sudden you throw something on there that says you can no longer rent. That would be problematic.
Okay, yeah, I just wanted clarification on that.
All right, so different types of improper notice. Again, statute and your governing documents are going to dictate some of these things, whether the notice is between 10 to 50 days. Some notices for different meetings might be it has to be within 30 days. Again, it's all very document specific. There are statutes that dictate how long you have to provide notice before the annual meeting or your budget ratification meeting, those types of things. Some are going to require that snail mail be sent out. Some might require physical posting. You're going to want to show what the time, date, and location of where the meeting's at. Obviously, there's a notice of amendment to vote. You're going to have to follow your governing documents to show, and the Nonprofit Act to show that you've complied with all of the requirements. Another thing that might have a different notice is a removal, notice of director removal. In terms of virtual meeting considerations, again, I think the hybrid ones are the hardest in terms of often the audio doesn't work quite right, people can't hear. Those who are in the audience, if someone's talking and asks a question, those on Zoom might not be able to hear. So if you're doing that, again, you want to think about those people who are there, and if that question comes from the audience, a good process is to then speak into whatever that computer is and say, here's the question that came from the audience, here's what it is, blah, 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 so that everyone who's listening virtually has the ability to hear it. All of these things can be problematic and things to take into consideration. Secret ballots. So with contested elections, if we're going to use secret ballots, and I think there's the next one might be proxies. Yeah, we'll get to proxies. So ultimately, when we're using secret ballots with a contested election, you want to make sure, again, you follow the Nonprofit Act. You go through all the steps of what's required for a secret ballot. If you know you're going to have a contested election, I would highly recommend you reach out to your attorney, have them walk you through what the actual steps are for that. A lot of your managers, if they're experienced, will know the steps, but it's always good to have something in writing from the attorney that says this is what you have to do. That way, anytime there's a contested election, there's almost always going to be someone on one of the sides complaining about the process that's being used. So being able to fall back on here's what the attorney has said, here's the process, here's what we're going to use is very beneficial. Having an attorney there can be helpful. Like I said, I was just at a recall meeting in Fort Collins 2 weeks ago maybe, and it was a hot nightmare. From the moment I stood up, the person was saying, you didn't check IDs when people were registering, when they were signing in to determine if they're an owner. Like, we're not checking IDs. Someone says this is who they are, we're going to take that for its word. There's all sorts of different things. If this person's an LLC, the property's under an LLC, is this person able to vote? All these things you want to have your attorney prepared for and be able to answer the questions off the bat. Versus you as board members trying to explain why a member of an LLC has the ability to cast a vote for that property, whereas a homeowner's wife or husband who's not on the title of the property does not have the ability to cast a vote. Like, all of these things come up, and you want to be as prepared as possible for this. If you're doing an election or trying to pass an amendment, I personally think the mail-in ballot process is the best way to go. Sometimes that might be cost prohibitive, but my personal opinion is that mail ballots are a better way to try and do it. One, typically it's much easier to get enough votes to meet the quorum to be able to pass it. And two, it gives everyone a little bit of time to actually review the information and make an informed decision. So quorum, again, depending on the type of meeting, it can change depending on your governing documents. Is it going to be a percentage of those that actually, so typically when we're talking about these things, there's going to be a quorum that allows the meeting to take place. So whether that's 10% or 20% or whatever it is. So you have to reach that percentage for the meeting to be valid. And then there might be another step that says, all right, once quorum is met, in order to approve XYZ, that is a percentage of all the individuals that have shown up at the meeting, either in person or by proxy. Or it might be something that says you need a percentage of the entire association to pass this. So again, all of it is very document specific. You have to look at all of those. Each document is different. They don't always make a whole lot of sense as to how they're done. Some documents might say that in order to have your annual meeting, you need a 20% quorum. If you don't get that, you can then call another annual meeting within 30 days and the new quorum is now 10%. There's all sorts of different things that might take place. It's also going to talk about, so is it going to be percentage of owners or votes or allocations? So if you are living in a condominium, you might not have, it might not be based on your ownership in terms of I own this unit so I get one vote. It might be based on square footage. So my vote is actually 0.0667, and this person has 1,000 more square feet, so theirs is 0.0072. When you're dealing with votes that are based on allocations, it's a nightmare for the managers trying to calculate all of that. But it's what the governing documents say, it's what we have to do. Again, virtual meeting considerations, we want to have, and again, if you have a management company, they typically are very good at having processes in place so that if someone's come online, we can document that they're there so we can show that they have quorum. All these things are possible mistakes that can happen at a meeting.
Quick question.
Yes, ma'am.
I'm sorry. What do you do if, if a person is obviously has code violations, violations, so they don't have a right to vote, and you're having a virtual meeting? Do you tell them you want, and they want to come on, do you just not allow them to be, you just don't let them into the meeting, or do you tell them that you, how do you deal with that?
They're certainly entitled to be at the meeting. And honestly, I would almost always default. Go.
I'd like to hear what he's saying, not what you're saying. So if we could let him speak and then we could like for us to get on
So yeah, so in terms of, sometimes your bylaws or your governing documents will talk about if an owner is delinquent or has a covenant violation, they're not entitled to vote. I would personally say you should still let that person vote. If someone wants to challenge it on the back end, they want to file a lawsuit and say this individual didn't have the right to vote and you guys shouldn't have let them vote. I think most courts are going to decide on the fact that because I didn't pull my weeds, you're telling me I don't have the ability to vote on who a board member is. I don't think that's a very logical argument. So my default would be to let anyone vote personally. If you're not going to let them vote, you also have to be very careful with what stage are you at in the violation process. So if we have only sent out a letter, a courtesy letter to them saying you haven't pulled your weeds, and the board then hasn't had a chance, the owner hasn't had a chance to approach the board and say, here's why I haven't, or here's whatever's going on, the owner at that stage probably isn't technically in violation because they haven't had the ability to actually contest their case. Same thing on the first fine. They have so depending on where they are, it's difficult, and I would personally remove all that and just say, look, if you're here to vote, you're here to vote. If someone really wants to challenge it, they can challenge it, but my default that I would tell the boards is let whoever shows up, go. Do you have a question, sir?
In the virtual meeting, you have to say, consider this for the owners. Are you going to have feedback to the room?
Yep, so sometimes, so sometimes people will need an interpreter. Sometimes people will need sign language or things like that. So sometimes reasonable accommodations do come in with meetings. Typically, in terms of if someone needs an interpreter or sign language, it's typically going to be at their cost. If it's a hearing impaired or something along those lines, each thing's going to be specific, and typically what we would want to do is, what we would say is if you want an interpreter, you need to tell us you're going to be at this meeting. We'll get the interpreter there. If you fail to show up at that meeting, you are going to be charged for that. if they show up at it, the association probably has to pay for the interpreter so that everyone has the same ability to participate. But we want to make sure that they're telling us ahead of time if there's consequences if they don't show up, things along those lines.
This person's not paying their dues.
Mm-hmm.
So then, should we still consider them to the whole? I mean, ours is, we have to be good at saying.
Yeah, I mean, the only time they're really voting is budget ratification, or some type of special meeting that's requiring maybe board removal or voting on board members. I personally, again, don't think a judge is going to say because you didn't pay, because you're 2 months behind or whatever it is, you don't have the ability to vote for who you think should be on the board. I think the association has a more defensible position to allow everyone to vote. I mean, ultimately, you're comparing them to a person in a state that has felons aren't allowed to vote, and we're deeming this individual to be a felon. Like, I just don't think that it's a great approach. All right, so proxies. We must allow proxies. You cannot limit how many proxies someone gets. You don't get to limit the type of form that a proxy is provided. We can provide proxies to individuals, but if they come with anything in writing that says I'm giving my vote to said person, that's a valid proxy. They don't have to have a specific form. There are specific requirements in terms of it has to be dated, it has to be signed, it has to clearly, so an email that says it's from Joe Smith's email to John Adams, that would be good. It doesn't have to be a wet signature, but you have to be able to see who the proxy was coming from and given to. So ultimately, they're not ballots. So when you have a vote and you're doing proxies, the individual comes, they have 10 proxies, that individual will then be given 10 ballots to vote. Whether the individual votes the way that the proxy says they're supposed to or not is an issue between the two parties, not an issue with the association. So ultimately, they show up, they give you the proxies, you hand them the 10 ballots, and then they fill out those 10 ballots. Yes, ma'am.
We have a situation in our community where the board actually holds an election process because of proxies as hostage. Because we have so many absentee people who don't know people in the community, they just say the board president, and so the board president votes multiple ballots. But none of those people know the real issues, and so they essentially hold the community hostage.
Yeah, I mean, so ultimately, you're basically describing like a directed proxy. But ultimately, if you want to combat that, those individuals who want to get on the board or things like that have to be more out in the community, have to go knock on those doors, have to get their own proxies. There's nothing that prohibits the current board from soliciting from any of the other members, hey, if you aren't going to be able to attend the meeting and you'd like to have me cast your vote, I will cast your vote, please provide me with a proxy. So there's no difference whether you're the board president or you're someone that's not on the board. Anyone can go out and try and collect those proxies.
Thank you.
Yes, ma'am.
At our last meeting, we had some proxies, but then an issue came up that we voted on, and the person who had the extra proxies voted on it. Since it wasn't on our agenda, could they use those proxies in that voting?
So I would say, I mean, without knowing the details, but if something was voted on at an annual meeting that was not on the agenda, I would argue that that was an invalid vote. The proxies part is irrelevant. It's the fact that it wasn't on the agenda. Yes, ma'am.
I would like to say this something in the back of your brain, that at some point we either were supposed to or we're no longer supposed to on proxies include the option for just including it as a quorum number, not for a vote as well. Is that a thing?
So a proxy can be for anything. So you could have the proxy that says, I could give my proxy to you saying, I want this only to be used for quorum. I could give you a proxy that says, I want you to use this proxy only to vote on the election of a board member. So, or it could be a blanket proxy that's only good for 11 months that says, I'm giving you my proxy to vote at the annual meeting for whatever votes are there. So you could do lots of different things with a proxy. It's not limited. Yeah. Yes, sir.
Our documents say in a board meeting, the board members cannot hold that proxy.
Okay.
And then of course, the members only can.
Mm-hmm.
Is that,
So again, board member is going to be different. So a board meeting is going to be slightly different. So your board meeting, you might have documents that say a individual board member can't give someone else the right to vote his or hers vote. Like that, I would say that's probably enforceable. That's different than denying all owners the ability to use proxies. So again, budget ratification meetings, another type of meeting that we have a bunch. Again, timing and notice. Typically, these are going to be at the same time as your annual meeting. Ideally, you call a budget ratification meeting, and then 5 minutes after that ends, the annual meeting's called, or vice versa. Ideally, that's how you want to do it. You could wrap them into one meeting, but it's cleaner to have two separate meetings. Yes, ma'am.
And if we separate those, so I'm a minute person.
Mhm.
Is it in, out for the budget ratification, in, out for our regular?
Correct. And so like on your notice, I would, yeah, yep.
Oh,
And so I would say the annual meeting is going to start at 5:30. The budget meeting will start 5 minutes after the annual meeting is adjourned.
oh.
And then document or vice versa, exactly, yeah. Again, you might have different quorum requirements for these versus other types of meetings. You have to have a budget ratification meeting, voting versus veto. So depending on if you're pre-Kiowa or post-Kiowa will dictate whether or not the association is actually approving, like voting on the budget, or simply there to veto it. So if they're there to veto it, then you have to get whatever that percentage is that says, hey, if we have this many people that say no to the budget, then the budget doesn't pass and it reverts back to whatever the budget was last year. If you have a association that requires actual approval of it, which would be, this is where I'm not the best at, which I believe would be pre-Kiowa, would be a pre-Kiowa meeting, then unless the budget is voted on, it's going to remain what it originally was. So you either have to approve it or veto it. So two different types of things. We moved to the veto process because, as you all know, it's hard to get that many. It's hard to get a quorum even to an annual meeting or to a budget meeting. So rather than having to approve it, it's much easier that if there is an issue, you get enough people that show up that want to veto it. That's a better process just because of the lackadaisicalness that we have and apathy that we have towards HOAs. Special meetings, who can request? Special meeting can be called by the board or by an individual owner. So typically your bylaws is where it's usually going to be found. An individual owner can petition the board to call a special meeting. You might need a certain amount of signatures to be able to get it on there. There might be requirements as to what the owner has to do in order to get the special meeting called. But assuming they meet those requirements, then the board needs to call the special meeting. Typically, the documents are going to say the board calls it. If the board doesn't call it, then you're opening yourself up to liability. So the board would then call it. They'd set the timing. The agenda is going to be whatever the petition that was sent around to the owners says that the agenda is. Who runs it is going to be somewhat of a gray area in terms of it's not a board meeting, so the board doesn't have to be there. The board doesn't have to show up to a special meeting. Oftentimes you see that with recall meetings. The board might just not show up. If the board is there, typically the board does end up running it, or the management company. Oftentimes, if you have a management company, it's easy to have them run it to try and diffuse all the situations. Sometimes management companies don't want to run it. But ultimately, special meeting can be called on anything. It doesn't have to be for someone to vote on something. It could just be we want to discuss issues in the community. If there is something that's going to be voted on, that's going to have to be on the agenda. Again, anything that's voted on will have to be on the agenda. All right, executive session. So there's only 6 acceptable reasons to go into executive session. You can do it to discuss an employment or current management contract. You can do it for discussion with legal counsel. You can do it to discuss criminal misconduct, statutory protected communications. Privacy includes delinquency referrals and violation hearings, or review advice from the attorney when the attorney is not present. So if you are going to have an executive session, these are the only 6 things you can talk about. If you're going to be talking about anything else, that's an open meeting. For an executive session, you're just in the regular meeting. Someone motions to go into executive session to discuss advice from the attorney or to meet with the attorney. The rest of the board approves it. You go into executive session. You then come out of executive session. The minutes would just document the fact that we went into executive session to discuss a legal matter. It's going to be pretty broad as to what's talked about in there. Typically, what you'll hear from HOA counsel is that you're not allowed to have a vote in executive session. It's not exactly true. There are things you can vote on, but the general rule is you don't vote in executive session. Typically what happens is you have a discussion, and then you come out of executive session, someone makes a motion saying we vote for the attorney to move forward with XYZ, then you have the vote outside it, so you have a documentation of what is taking place in terms of the vote. And when you're dealing with privacy type concerns, so if we're dealing with delinquency referrals or violation referrals, violation hearings, the best way to document that is most of your management companies will have some type of reference number that's unique to the owner. So you refer to that reference number versus referring to an address or a name to help keep that privacy there. So something that we can go back and say, account 456, and then we go to the management company, account 456 is attached to property number 123 ABC. That way, we have a clear record of what's been done, but it's not thrown out to the world that this individual is delinquent or this individual is alleged to have committed a covenant violation.
May I ask, so do we have to even mention anything about, I mean, because we did recently act on some things in the executive session that I just kept it, that it was some violation matter, is how I wrote it, but
yeah, so
I wasn't given that number.
So ideally in the minutes you would want to say executive session was held for delinquency matters. Then you come out of the executive session, the board voted to churn these 3, exactly, however it's referenced, but these 3 properties over to the attorney for collections. Fairly specific, because we want to be able to, when we go to court and someone challenges did they actually churn me over, we want to be able to show the document here, Your Honor, here's the minute meeting that says file 123 was churned over, file 123 coordinates with this property address. All right, improper motions for the floor. Again, membership meetings, what can owners vote on? We've kind of hit on this numerous times. But again, if it's not on the agenda, they're not going to be able to vote on it at the membership meeting. As long as it's on the agenda, then you're going to have to hold the vote. At board meetings, there's no motions from owners. So they can't force the board to vote on anything at a board meeting. Again, you're going to have an open forum. You can limit that to 3 minutes per person. Here's what I want to talk about. If someone has something that I think is going to take longer than that, they can ask the manager or the board to put it on the agenda and we can discuss it. But the owners don't dictate what the board meetings are. The board dictates that. All right. That's all the substantive material. Questions? Yes, ma'am.
This past year, I participated in the Department of Regulatory Agency's Division of Real Estate Task Force on HOAs.
Okay.
And they came up with 52 things they're recommending to the legislature. Do you think that any of those will be passed? Will most of them be passed? I mean, they're fairly restrictive. Board members are going to have to get education. HOA management companies are going to have their management people certified. I mean, really good stuff, but
Yeah.
I don't know how likely it is any of it's going to get passed.
So I listened to most of those meetings. I think some of the ideas were very good. Whether or not it's going to become legislation is really hard. Anytime that legislation is tied to money, so if there's something, some of their ideas like funding basically a new administrative court to deal with HOAs is going to require a bunch of funding. I'd be very surprised if that type of law would pass. Things along the lines of making more restrictions on foreclosures or more restrictions on collections, you're going to see more bills like that will come out. Manager licensing comes up every couple of years. It failed the last time because there was a note that was attached to it. There was a monetary side to it. And that's why It's my understanding of why Polis vetoed that. The reserve fund, again, I think is going to come up in some manner. I think in theory, it's a good bill. Everything that seems to be coming from the legislature right now is trying to reduce costs. However, every single thing they've adopted has increased the cost. So it's a fundamental misunderstanding, I think, between the industry and the legislators as to, I think everyone wants a similar goal, it just is trying to get there. But every time they pass these new laws, it costs, you have to hire attorneys to draft new policies. As of right now, they're limiting attorneys' fees on collection cases. So ultimately what they're saying is that we don't want the individual violator to be responsible for all of these attorney's fees. We want the entire community to be responsible for the attorney's fees. And what that means is you have to budget more for attorney's fees. So ultimately, everything that they are doing right now is rising costs. There's going to be a huge conversation, I would assume, on insurance, because everyone's insurance, HOA insurance, especially for condominiums, is through the roof. I mean, they're going up 300, 400%, especially in older communities. Boards have oftentimes prided themselves on not increasing dues. Anytime I see an association that hasn't increased dues in a couple of years, they're in financial problems. It's a big problem. The only way you can do that is by deferring maintenance. And so it might be great for that individual who then has moved out during that time frame, but for those people who are there when the maintenance hits, we don't have the reserves, we don't have the ability to pay for it. It's going to be huge special assessments. And it's a problem. So I can't give you an answer as to what I think will pass or won't pass. I can guarantee you there will be multiple bills. I can guarantee you there will be bills that were discussed there. There will be bills that weren't discussed there. I mean, Representative Ricks is going to propose bills. The other individual, who I can never remember the name of, is going to propose bills. There's going to be more HO bills. So, question over there?
Past those examples, the maximum fine in a year is $5,000.
So not in a year, but per violation, yep.
Okay, so we have a city, let's say we have to road something that's C, then C, then continue to drive. The fine $500, he said, that's cheaper than somebody. So I'm just gonna keep it. What can I do for it?
So just like with any other violation, the fines are just your first step. So you go through your enforcement policy, you send the courtesy notice if your policy has that, send the first violation, give them 30 days to cure, send the second violation, give them 30 days to cure. If they haven't cured after that, you turn it over to the attorney files a lawsuit and gets a court order requiring the truck to be moved. So the fines are just the first step. And that's really the point of the legislation, was that associations, rather than truly dealing with the problem, they were just tacking on fines and fines and fines. So the fines obviously weren't working. The person was fined $3,000 and nothing changed. And the association didn't change its approach, it just kept fining and fining. So really what this did is it puts a cap on it, so the association then has to act. You either have to decide that this bothers me enough that I need to turn it over to an attorney to get them to actually go get it removed, or it doesn't bother me enough and we're just going to live with the fact that the violation's there. So ultimately it's putting the onus on the association to make an actual decision. Is this really a violation? There's a question over here.
I have a couple of questions for you. On page 11 of your handout, slide 33 of the Colorado Twist, you basically say that you must accommodate for a service animal in training and a trainer of a service animal. My question is as follows. If you have a service animal in training in your association, and that animal should attack another member of the association or guest, and there's an injury, who's liable?
Who's liable?
Yes, who will pay for the injuries?
I mean, the association is going to get sued. The owner of the dog will probably get sued, depending on where it happens. Ultimately, dogs get a one bite free kind of thing. So the likelihood, if this is the first time the dog is attacked, the likelihood that the association is going to be found liable for anything is slim. Now, that doesn't mean the association is not going to spend a bunch of money defending itself. But I think the liability is probably pretty small to the association. And honestly, with that, the association that's something that's going to be covered by your insurance. So you'll pay your deductible, and then insurance defense will come in and deal with the rest of it. Any other questions?
Yeah, this one's off topic. What's the current status of the Corporate Transparency Act?
Good question. So I either read the email today or yesterday. CAI filed a new lawsuit trying to get a temporary injunction to stop it from going into effect on January 1st as applying to associations. My personal belief is that associations are going to have to comply with it this year. I don't think that a court's going to grant the preliminary injunction personally. I think that all associations are going to be required to at least do it this year. There's a possibility down the road that we might be able to carve out an exception for associations, but I would say that probably all associations are going to be required to comply come January 1st.
Follow up. What is the status of the CTA case that was held unconstitutional by the Northern District of Alabama? What is the present status of that case?
I don't know the present status, but I know that an injunction has not been entered saying that it can't go into effect.
Okay.
I'll hand over. Yes, sir.
So, how do you change
Yeah, they're going to have to you're going to have to tie it to the association. Ultimately, what we are going to be recommending to associations is they amend their bylaws so that if a board member refuses to provide this information, that they are immediately disqualified from the board. Otherwise, you're going to have to go through a recall process, and you have only 30 days to update the CTA with any changes. So if if a board member is not doing it, for us to go through a recall process in 30 days is probably not likely. And so you're exposing the association to liability. There's also criminal issues, but I can't envision any actual criminal ramifications for an association. But I do think some association somewhere across America is going to be hit with fines, and they're hefty fines. Yes, ma'am.
What recourse does an HOA board have when they have maintenance that's required by an owner on a limited common element, and they don't need it, or say they can't afford it? What recourse does the board have to get that maintenance done?
So it's just like any other violation when you go through your enforcement policy. If the governing documents say that, typically in terms of a limited common element, the maintenance is going to be simple in terms of like you just need to keep it swept or neat or I don't know what.
A destroyed driveway. Concrete, serious concrete.
And the owner is the one who's responsible for the maintenance of the driveway?
The maintenance matrix, the owner's responsible.
Yeah, so ultimately it's a covenant violation. They're violating the covenants by not doing it. So you go through your process. If they don't do it, you turn it over to the attorney, they file a lawsuit, you get a quarter of the requirement. Yes, ma'am.
In that same vein, if the limited common element is something mildly structural, like a porch, or something like that, I'm assuming the association would be responsible for the limited common element, for then stepping in and taking care of it and billing back to the owner, or would you recommend sticking with a violation?
It's going to be document specific. So two different things. If it's the owner's maintenance responsibility, you're going to treat it just like any other covenant enforcement matter. If it's the association's responsibility, the association needs to get in there, fix it. And then there's the third layer of it, is the association may have, depending upon the governing documents, may have the ability to charge back the cost of that repair.
If the porch is the homeowner, is a limited common that the homeowner is responsible for, but there's like a beam that supports part of the roof or something, and that's the association, would it still be that same situation? Or would it be a better idea to just go in and fix it if they're not responding? And because we're gonna be responsible if that porch keeps crumbling, the beam comes down.
Yeah, your best advice is to go talk to whoever the association's attorney is and have them actually look at the documents and give you the general advice. In terms of general advice, if there is something that has the potential of causing more structural damage to something that the association is responsible for, I would worry less about the money and more about getting it fixed, and then we can deal with the money on the back end.
You said you have an office in Loveland now?
We do. We've had it for 7 years, maybe.
We've used altitude level anyhow's been very happy, but I gave her a different office. How do we find the Anderson phone number? Just Google it or?
So all the phone numbers will come to our Lakewood office and then they'll get redirected. So David Clausen is the attorney. He's another one of the owners. He mans the Loveland office always. It is over by the Loveland outlets. There's like a McDonald's and a Taco Bell, and then across the street from that is there's like a complex, and we're right in there. So we have 2 offices open. So I mean, I'll work out. David works there every day. And then we have multiple other attorneys like myself that might come up for a day a week or things like that. We have conference space and stuff. Thank you. Any other questions? You don't have a choice.
Why would anybody want to marry?
Thank you, everyone. I really appreciate it.